No worries. It feels like it's
It's gibberish right now.
All right, good morning. Can those of you on the Zoom hear me?
I can hear you.
Great, okay. Welcome to the January 17th, 2024 Mineland Reclamation Board hearing. I am your chair, Nell Wareham. We're going to start with a quick roll call and we'll get going. Mr. Mock,
Present.
Ortiz,
Present.
Nelson,
Present.
Stegelmeyer is on the line.
Yes.
And Mr. Baker, I believe, is on his way. So we'll get going through some things and then we'll make sure we have that. Looks like we've got the updated tentative agenda. So we'll start with the approval of the December 2023 summary of minutes.
So moved.
Moved by Ortiz, seconded. Second. Nelson, okay. Any discussion? Those in favor signify by saying aye.
Aye.
Aye. Those opposed? Okay. Continuances and withdrawals. I don't believe we have any. Is that correct?
Yes.
Correct. Okay. No continuances, withdrawals. And then executive director's report, Mr. Mock.
Thank you, Madam Chair. Good morning, members of the board, Acting Director Cunningham, Tim Mock, Deputy Director with the Department of Natural Resources. Make yourselves comfortable. We've got quite a few here. Better not catch anybody sleeping. I think as everybody's aware, right around the holidays there, Parks and Wildlife successfully reintroduced 10 gray wolves back into Colorado. We commend Parks and Wildlife. It was an exceptional effort, leading that effort from the passing of Prop 114 to today. It ran literally like a shuttle launch. We are now conducting after action reviews to see and understand what went well and what could be improved upon for future successive releases. We expect over the next 3 to 5 years to be releasing 10 to 15 wolves each year. We may still reintroduce 5 more between now and March. Staffing updates in the executive director's office here. I think also, as most know, our state engineer, Kevin Ryan, retired at the end of the year. So we are now advertising for the state water engineer position. Ultimately, this position is hired by the governor, but the DNR is leading the selection process, and our executive director, Dan Gibbs, will be involved in the selection of a final candidate. We are also interviewing candidates for a vacant federal affairs policy 4 position and for an assistant director for research for the Produced Water Consortium. And then the DRMS director position is in process. We may have an announcement within the next week or the week after on a new permanent director. The 2024 legislative session has commenced last week. Just a reminder that Daphne Gervais is our legislative director. We would kindly ask board members if you engage in any conversations regarding the MLRB that you inform staff and let Daphne or at least keep her apprised of those conversations. 2 weeks ago, Department of Natural Resources released a pollinating insects study. In response to Senate Bill 199, we contracted with a team of subject matter experts from CSU Extension, University of Colorado Museum of Natural Histories, and the Xerces Society. And they worked with a team of researchers and subject matter experts, department staff, program managers throughout state government, including CDOT, Department of Ag, Parks and Wildlife, State Land Board. I know DRMS had a couple of comments and participated a little bit. We appreciate everybody's participation. The study establishes important baseline information, including a synthesis of the research providing evidence for the importance of native pollinating insects to agricultural and natural resources within the state, including key factors impacting their diversity and health, what conservation practices are currently in place, and future priorities for enhancing pollinator insect health. copy can be found on our website. A couple of, on the federal policy front, we recently submitted comments in support of the U.S. Forest Service's proposed mineral withdrawal for the Thompson Divide. Proposed action reflects key provisions within the Core Act that designed to maintain traditional land uses in and habitat connectivity in the region, which DNR and Governor Polis have long supported. DNR is also actively working to develop comments on several key wildlife habitat-focused Department of Interior land use plans, including greater sage grouse, Gunnison sage grouse, and the big game RMPA. And then DNR, we submitted our comments in mid-December on the BLM solar programmatic environmental impact statement with input provided by Parks and Wildlife staff. And we expect the draft solar PIS to be available for public comment in early 2024. And then DNR and Parks and Wildlife are working to develop comments on the U.S. Fish and Wildlife Service's interim 4D ruling for wolverines. I think you might remember that asking the legislature for permission to reintroduce wolverines was one of our legislative priorities for this year. We're currently evaluating that in light of the service's threatened listing of wolverines and then implementing a 4D ruling process in conjunction with that. The Colorado Strategic Wildfire Action Plan co-swap, our second round of workforce development grants, closed in fall of 2023. We received 33 applications for wildfire mitigation work to be completed by the Mile High Youth Corps and the Department of Corrections. ECMC will have a busy year rulemaking this year. We anticipate rulemakings on cumulative impacts, deep geothermal operations, and carbon capture and sequestration projects. ECMC is also collaborating with Parks and Wildlife on a rulemaking to update the high priority habitat maps for 2024. And then they are conducting studies on geothermal technology and regulation and carbon capture technology, among other emerging technologies. CWCB released a climate report. The much anticipated climate change in Colorado report was released to the public on Monday, January 8th. The new multi-chapter report combines and synthesizes relevant climate science information to help inform future management and planning of the state's water resources. The authors emphasize an uncertain and more variable water future for Colorado. So the report will be critical in guiding decisions in the years ahead. And then we continue to work through the Colorado River. I think I mentioned this past June, the Department of Interior announced a formal process to develop the future Lake Powell, Lake Mead operating guidelines to replace the 2007 interim guidelines. And the basin states are currently working together in an effort to develop a consensus approach for post-2026 operations that the federal government could implement through a NEPA process. And then the Colorado River Drought Task Force, created by Senate Bill 23-295, submitted their final recommendations to Colorado General Assembly on December 15th. Some of the legislative concepts that received the favorable vote include investing in improvements to aging water infrastructure, turf replacement, emerging water measurement technologies, local capacity building, grants for water projects, integrating watershed health into community wildfire plans, and expanding the in-stream flow temporary loan program and agricultural water rights protections. And that concludes my report, Madam Chair.
Thank you. Any questions or discussion? Acting Director Cunningham.
Thank you. Good morning, Madam Chair, members of the board. Let's start off the update with a brief note on the Schwartzwalder mine. As the board knows, at the December hearing, we went through permit revocation and financial warranty forfeiture. The division does have the $7.2 million in hand that's sitting safely in state treasury. Right now, we're working on a number of different things. The Inactive Mines program is putting together a request for proposal to have a contractor in place at the beginning of the treatment season. And the other main tasks that we're working on are securing the permits that are needed to actually operate that water treatment facility, namely a discharge permit and a radioactive materials license. So we are working on that, and that's going to consume a lot of our time between now and May. But we will continue to provide updates to the board as we move through this process. I am excited to announce that the Active Minds program just yesterday announced a new position for an EPS-3 geochem position. This is an internal promotional opportunity, and that job posting closes on January 31st. As you can imagine, we've got a great need for this role, especially on the hard rock side of things. This position will, amongst many other things, analyze geochemical data, perform mine waste characterization, evaluate the potential for acid mine drainage, review acid-base accounting analysis, whole rock analysis, and even assist with groundwater hydrogeology. So we look forward to informing the board here shortly after we get through the interview process who has been selected for that. And as a reminder for the board, with the addition of this geochem 3 position, that brings us to 6 EPS-3 positions within the Active Minds program. We will have one for geochem, cost estimating, groundwater, surface water, engineering, and vegetation noxious weeds. So I think we're in a really good place. We've got a broad and well-rounded skill set amongst our staff, and we're excited to add geochem to that list. My last update for the board, I'm a little sad to have to announce that our very own Tim Kazir is going to be retiring on March 1st. This will be his last hearing before the board. Tim has been with the division for 13 years and 3 months or so. He came to the division with a wealth of experience and has been invaluable to staff in his time here. Tim has served as the division's engineering EPS-3 since February 2020 and has been our primary staff member in charge of conducting engineering-related reviews. Just a few things to note about Tim and some of the great work that he's done here. In March of 2018, Tim developed and received board approval for the board policy for minimum factor of safety for slope stability. This policy provided clarity and consistency to staff and the regulated community on how to demonstrate minimum factors of safety for stability-related issues at mines. In addition, on the side, in his evening time, when he's not working on inspection reports, Tim has also been involved in the Association of State Dam Safety Officials and has served on the Tailings Dam Subcommittee and contributed to the Tailings Dam Supplement, which is going to be contained in an appendix for the Model State Dam Safety Program. So this is a guidance intended for regulators who are tasked with oversight over tailings dams. So while we're going to miss Tim tremendously, we wish him all the best of luck in the next chapter. And that concludes my updates, and happy to take any questions from the board if there.
Thank you. Congratulations, Tim. Enjoy.
Thank you, Tim.
Anything else from anyone here before we move in here? See if that was Bill. No. Okay. So item number 4 is on the consent agenda. This is Thorn Resources, file number M-2012-032. Mr. West. There he is. Anything we need to know, any discussion on this?
No, ma'am. This all the board board materials in your packet outline that this is just a status change to go from temporary cessation to active.
Okay. Anyone like to entertain a motion?
Motion to approve the consent agenda.
Mark, second?
Second.
Nelson, second. Discussion? Those in favor signify by saying aye.
Aye.
Any opposed, same sign? Hearing none. Item number 4 passes. Thank you, Mr. West.
Yes, ma'am.
Hey. Next one is number 5. This is an enforcement hearing for K&B Mining LLC, file number P-2013-19. Mr. Lindbergh. Anyone who will be testifying in this hearing, please swear to tell the truth. Do we have operators?
He was. Yes, he's there, Mike Mutter.
I'm sorry, what's his last name?
Mutter.
Mutter?
Yep.
Okay. Mr. Mutter,
I'm-
can you hear us? Yeah, you swear to tell the truth?
Wait, swearing, his name is Pat Farr.
Oh,
He's logged on to a different computer.
okay. What's the
We need to swear in Pat.
Pat Farr?
Yep.
Thank
Yeah,
you. All right. Patrick, the floor is yours.
Did I just say the floor is yours?
I don't know what's going on.
But what are you asking him to do exactly?
We were just swearing anyone in who intended to testify. So the way that this will work is the division will give an overview of the enforcement hearing, and then I'm imagining there will be some time for the operator to either weigh in or have any kind of more discussion, and then we will discuss the matter. So I think for now, we'll just be hearing from the division. We'll let you know when we are ready to hear from you.
Great, thanks.
Yep.
All right, my name is Patrick Lindberg, and I will be representing the division in this matter. This is an enforcement hearing for the Badger Group of Mines, P 2013-019, permitted to K&B Mining LLC. This is an enforcement hearing for the consideration of a possible violation, civil penalty, cease and desist order, corrective actions, permit revocation, and finding financial warranty subject to forfeiture for failure to comply with the conditions of the board's order, permit, or regulation. The site is located in Boulder County, approximately 1.8 miles east of Jamestown, Colorado. It is a prospecting NOI for 1 acre. Prospecting was done for gold and silver. The NOI is located on private property as well as U.S. Forest Service land. The financial warranty is $11,426. It is a cash bond, and it is adequate at this time. This is a map of the both the private land as well as the NOI. The NOI is located is outlined in the black boxes. So where the arrow is with the trench location, that is one area. And then Portal 2 over here is the location of the other area. Portal 2 is located on U.S. Forest Service land. Brief chronology: on February 6, 2023, the signed MLRB order found the prospector in violation of Rule 5.1.2, Parent D, Parent 6, for failure to maintain legal right to enter, and Section 3432-116, Parent 7, Parent Q, and Rule 3.1.3, Parent 2, and 5.3.1, Parent G, for failure to complete reclamation within 5 years of ceasing prospecting activities. On August 5th, 2023, the board ordered deadline to demonstrate the legal right to enter across private land and obtain a new plan of operations from the U.S. Forest Service to complete reclamation at the site and complete reclamation of the affected land. Can do. On December 6th, 2023, the division conducted a site inspection prior to the January 2024 board hearing. During the inspection, it was determined that reclamation had not been performed at the Rip Van Dam portal located on U.S. Forest Service land in accordance with the approved reclamation plan. The other NOI locations were largely reclaimed to the approved plan.
December 7th, 2023, DRMS sent the prospector a reason to believe a violation exists and notice of board hearing letter for failure to comply with the conditions of an order, permit, or regulation. December 21st, 2023, the division received payment of the unsuspended portion of the civil penalty, which was $1,000. This is a shed that is located at the Rip Van Dam portal, located on US Forest Service land. It is to be removed according to the approved reclamation plan. This is the portal entry of the Rip Van Dam mine. Notice the debris and whatnot like that located at the portal entry. There is this fifth wheel trailer that is there. It's unknown exactly who owns it and who brought it there, but it also needs to be removed. Reason for the violation: CRS 3432-124 requires the prospector to comply with the conditions of a board order. The prospector did not comply with the condition of the board's order for violation PB 2022-001 for failing to comply with the corrective actions required by the board's order. The due date to demonstrate the legal right to enter and perform reclamation was August 7th, 2023. Therefore, failure to comply with the conditions of the board's order to correct such violation constitutes a default under the prospector's performance warranty. Staff recommendations: find the prospector in violation pursuant to CRS 3432-124 for failure to comply with the conditions of the board order for violation PB 2022-001. Cease and desist order. Reaffirm the cease and desist order issued by the board at the December 14th, 2022 board hearing, which prohibited any further activities on the affected lands except those activities approved by the division in writing as necessary to comply with the conditions of a board's order, prevent damage to offsite areas, complete reclamation, or to protect public health and safety until the corrective actions have been resolved to the satisfaction of the division. Civil penalties. For violation PB 2022-001, the board previously imposed a civil penalty of 56 days at $200 per day for a total civil penalty of $11,200. All but $1,000 of the total assessed civil penalty was suspended if the prospector complied with the corrective action in the time specified. The division is not seeking any additional civil penalties in this matter. Staff recommends the board affirm the total civil penalty of $11,200 is due and payable. Permit revocation. Pursuant to CRS 3432-124, parent 6, parent A, upon determination after a hearing that a violation of a permit provision has occurred, the board may suspend, modify, or revoke such permit. Staff recommends the board revoke NOI number P 2013-019 pursuant to CRS 3432-124, parent 6, parent A. Finding the financial warranty subject to forfeiture. Pursuant to CRS 3432-118, parent 1, a financial warranty shall be subject to forfeiture whenever the board determines that one or more of the following circumstances exists. A, the operator has violated a cease and desist order entered pursuant to section 3432-124, and if corrective action was proposed in such order, has failed to complete such corrective action, although ample time to do so has elapsed. And or B, the operator is in default under a performance warranty and has failed to cure such default, although the operator has been given written notice and had ample time to do so. Finding this financial warranty is subject to forfeiture continued. Staff recommends the board find the financial warranty for NOI number P 2013-019, subject to forfeiture pursuant to CRS 3432-118, parent 1, parent A, and parent B. Staff requests the board to direct staff to schedule a hearing for forfeiture of financial warranty and send proper notice to the operator and the financial warranty. Were there any questions?
Thank you.
Yep.
Any questions from the division? No, is there someone in the back? Sir, are you part of the operations?
Me?
No, I've got a gentleman in the room here with his hand raised behind Patrick.
No. Hey, what's up?
Try and offer a few facts.
Are you part of the operation?
You have to state who you are.
Oh, I'm Frederick Solheim. I'm an advanced degree geophysicist and I've been trying to help Patrick Farr with this issue with the Brookbend Dam.
Just a quick, so just real quickly, we already swore people in who were testifying and
Sorry.
I just had Mr. Farr on the line as the operator swear in.
I'm not the operator.
No, I understand that. Excuse me.
They're kind of out of sight. They're the ones that have to hold the bond. They're the ones that seem to be the center of this problem.
Right.
Yeah.
But at the beginning of this matter, when we called attention to the agenda item, and I asked who would be testifying, I said, does anybody, who all will be testifying, who's here to testify? Please swear yourself in. It's the division and Patrick is who I am, not Patrick,
Yeah.
Mr. Farr, Pat Farr, is who I have.
Pat's in Texas.
Okay,
Yeah,
that's fine, but
he's
he's here,
online.
he's on the Zoom. This is a hybrid meeting.
Oh,
He's on Zoom.
He's on Zoom here.
huh.
He swore himself in.
Right. Can I talk to him?
So it's a little out of process here.
There's
but-
public comment, right?
Well, there's an underlying problem. Access to that claim has been denied by a property owner down by the creek.
Okay, I think we just heard a division report on the issue. At this point, what we're in is we're asking anyone here on the board if they have any questions for the division because they just presented the case there. And then we have the operator on the line and we just explained to him that right after the division talks, then we will ask the operator if he has anything to add for that, and then we'll have board discussion. So I think right now, what's on the table right now is just, we just need the board. If anyone has any questions for the division, that's where we are in the hearing process right now.
Okay, point of clarification. Farr is the operator, I mean, not the operator, he's the owner, 30 years. Brewster and Kennard was the operator, permit holder. And they're just sort of out of sight. They're the ones that created violation.
Okay, but at the beginning, when we started this hearing, I said, is there anyone here who intends to be part of this hearing? And I asked everyone to swear themselves in, to swear to tell the truth. And
Well,
Didn't hear anything
I was
from
a
you.
little late. The parking meter was smarter than me. It took a while.
it is, yes, I had a trouble with the parking meter too, but right now, we're asking if anyone on the board has any questions for the division. Okay, thank you. So Mr. Farr, do you have anything you would like to add or elaborate on regarding what's been presented or anything about the operation or these considerations?
Yes, I do.
Okay, we're gonna just stop. There we go. This way we can see you better. Okay.
Okay, what I would like to get a better understanding of is that last December or last January, I believe, or February the 8th, an order was issued that I get legal access to my property. And that was an order that the board ordered me to do, was to get legal access. I have attempted to do that, and the guy that has the private property where the entry to my property intersects the public highway has refused to give me access to my property. I have retained a lawyer. The lawyer told me that I could spend hundreds of thousands of dollars and never get legal access. There are no guarantees. So my problem is I have been using that Forest Service road to access my property for over 50 years without a problem until the current landowner who purchased the property at the intersection filed a complaint with the board, and the complaint had this hearing and ordered me to get legal access, which I cannot do. The attorneys have advised me not to sign anything that the landowner at the entrance to my property wants me to sign, because it would give up my rights to my existing rights. So what I think has happened is the board has given me an order that I cannot make happen. When I discussed this with Patrick, he is aware of the situation. He has met with the landowner. He has not met me personally, but I've talked to him on the phone about the situation. I have done everything that the board asked me to do that I could do, and that was pay the $1,000 a portion of the fine. I could do that, but I did that as Pat Farr, not as president of K&B Mining. I loaned K&B Mining the $1,000 so it could pay that $1,000. My intent is to do everything I can personally because I own the property there. K&B Mining has been inactive since 2016. It was ordered to cease and desist, and the only thing that's happened on that property is a bunch of vandalism since 2016, and it continues to this day, cutting locks off of the gates, and I don't have any control over that. All I can do is lock up the property, and if somebody cuts it, I live in Fort Worth, and that's 950 miles away. So I don't have any way of going up there and watching that property 24 hours a day. The Forest Service tells me that they can't approve a plan of operation until I get legal access from the landowner, the private landowner. I own 4 times as much land on that road as the guy owns at the entry to the highway. So what I'm trying to say is K&B Mining, the only asset that K&B Mining, which was ordered to do all this stuff, and since I'm involved with K&B Mining, I guess as a spokesperson or as the one that's been filling out the reports every year, K&B Mining has no asset other than the bond that's up with the state. And to do the remediation, what I would like to see done would be that the board take that bond money, and which is adequate to do the remediation, and let the board decide who does the remediation, not K&B Mining, because K&B Mining, as far as I'm concerned, does not exist. That's kind of what I guess I needed to get off my chest.
Yeah, thank you. So you heard the staff recommendations on the table?
They're well, if you don't mind repeating it, I've got a lot of things on my mind, but
Yeah.
Repeat what the staff's recommendations are.
Sure, yeah, I just want to make sure that what
Outline.
he's saying sounds appropriate. feels in line with the staff recommendations, just to make sure they're.
Right. So, Mr. Farr, I'm Chuck Coyman. I'm the board's attorney. I've just run through what the division's recommending here. And one's to find a violation for failure to comply with the previous order. Two is to, reaffirm the cease and desist order. And then they're not seeking the imposition of new civil penalties, but the unsuspended portion. So the $11,200 that was suspended in the previous order, asking the board to, affirm those penalties that are due and payable now. And then revoke the notice of intent, the prospecting notice, and then move forward with the forfeiture of the financial warranty by finding the warranty subject to forfeiture, and then starting the process by issuing notices and setting the forfeiture for a future hearing before the board. Does
Okay,
that make sense to you?
well, I really think I have not personally violated any rules to justify any kind of a penalty on my part. K&B Mining has no assets. So if, if they're fined 100,000, so what? I don't think that's my role to pay that fine. And I don't think that I have violated any rule personally. K&B does not exist as far as I'm concerned, and it was ordered back last year to cease and desist. And the only activity that's going on up there is vandalism, and I can't control that. And I don't think I'm responsible for that.
So in following the staff recommendations, would you concur that kind of following that pathway would help to manage the property appropriately and begin kind of reclaiming the area, making sure that the vandalism is not happening? Do you feel like you're in alignment there with your desires for the operation and what the division is A, recommending, and B, following up with based on the previous board orders?
Well, I do. I have no problem of agreeing to whatever the board decides to do with what they have to do with. Now, the Forest Service has posted, that nobody is to go up that road. Well, they can't keep them out either.
Yeah.
Because it happens, and they are there. So I can't keep people from going up there because I'm in Fort Worth, Texas.
Yeah.
So I don't think that I should be held responsible financially in any way for what vandalism does on that property. Does that make sense to you all?
Yeah, we hear what you're saying.
Just one point of clarification,
Yeah.
Jared Ebert with the division. Our recommendations are towards K&B Mining. I mean, Pat Farr, as we know, is a representative from K&B Mining, but it's not against Mr. Farr personally. All of our recommendations are geared towards the current permit or the current NOI holder, which is K&B Mining.
That's who's liable.
That's who's liable. Yes.
Yeah, I understand K&B is liable. I understand K&B has a bond up that's been up since 2013 or 14, and that bond was supposed to be put up in case K&B failed to do what they were supposed to do as far as remediation is concerned. Mr. Cunningham was the one that determined the price of $11,400 back in 2014, and Patrick says that is still sufficient, which I think it's more than sufficient to remediate less than an acre at the portal of the Rip Van Dam. And all the other stuff that's on private land up there, I asked to leave everything in place because I still own the land, and I've owned it for 51 years. and I have no intention of getting rid of it at this time.
Madam Chair,
Yes.
as you know, and stuff, the board has the authority and stuff and that to suspend or relieve any kind of civil penalties. Staff would not be objective. That was reduced or forgiven.
Thank you.
I understand the board has the authority to do whatever it wants to do as far as civil penalties are concerned. I guess what I'm saying is I don't deserve a civil penalty for what I've done or for what K&B has done because K&B has been inactive. And I don't think the civil penalties should be imposed on what vandalism has occurred up there over the last 5 years. I object to the civil penalties, I guess is what I'm trying to say. And K&B, the only asset it has is the bond that it has up. And if that's sufficient to take care of the problem, do it. I can't.
Okay, any further testimony needed from the division or any further clarification from the division? Mr.
Well-
Farr, do you feel like you've kind of said what you need to say? Because at this point, what we'll probably do is just go into board discussion about it so we can sort of discuss some of these staff recommendations, but I don't want you to feel cut off.
Well, I am in total agreement with making the remediation what it needs in order to get this thing over with. I'm in favor of that. And I think that the bond is sufficient to make that happen. But I do think that the board has the authority to exercise its right to use that board bond money to effect with its, I guess, whoever does work for them, to make the remediation happen. I can't do it because I can't demonstrate legal right at this time, even to my property.
Okay, thank you.
Okay.
At this point, I think we've heard some good information. I'd like to open this up for any questions that the board has, and then we'll have a motion and some discussion as to what to do with several of these. We've got several recommendations here. Any questions?
Can we ask a question of the DNR?
Yeah.
Does DNR have, if this falls into the care, the bond is released, does the DNR have access to this property to clean it up?
We would have to work, the inactive mines program would have to work with the Forest Service and that landowner to gain access to do reclamation service.
It's our understanding from the inactive mines program that they actually have worked with the landowner and they have a relationship that probably can make that happen.
The landowner did state that he would be amenable to allowing IMP across his property to do whatever reclamation needed to occur.
Thank you.
Madam Chair, does the bond adequately cover
Yes.
the work that needs to be done?
Yep.
And then question about the civil penalty. I understand that $1,000 was paid. Is that separate from the 11,200, or would you deduct from that? So that would be 10,200 due and payable.
It would be 10,200 would be due and paid.
And then what is there? Could you articulate what the board has done in the past where in this circumstance you had what I understand, correct me if I'm wrong, a change in property that includes access to a mine site. Is that a civil penalty that we would further enforce when that's less of the fault of the operator? I mean, I understand the operator has to maintain access, but in this case, what are the options if you have a property owner that purchased the parcel and then shut down the access that he's had previously?
Yeah, and it's an unfortunate situation. We do sympathize with the challenges Mr. Farr has had working with the Forest Service and this landowner to gain access. We were in communication with the Forest Service to do what we can to bring this to some type of closure, and it just seemed like we finally got to an end point where there was nothing we could do to get around that one landowner. You know, when we came before the board with the initial violation, we gave the span of penalty based on the statute. And the board found, you know, the penalty based on that span. In this particular case, what I've seen the board do in the past is it kind of what Russ was alluding to. We'd be okay with, you know, waiving the remainder portion of the civil penalty. We do agree that, yeah, Mr. Farr has done his level best to gain access, and it's just not, that does not appear to be happening in his favor.
And in the lifespan of this mine, has the operator been a good partner to work with, or were there previous infractions or?
So, he's been compliant for sure. What Drew issue was, Pat Farr was in the process of selling some of that land and wanted to sell the land where the NOI is partly located. Well, those individuals kind of went off the map and started intrusive activities in areas that weren't part of their property that they were interested in buying, which provided a complaint from the landowner to us. We investigated it, got them to stop their intrusive activities. In the process, they were also at the Rip Van Dam portal that you saw, and they were trained to, it's unclear exactly what they were doing in that portal, but we got them to stop that as well. The Forest Service was involved and whatnot like that. That's what drew more attention to this NOI. During the research of that complaint and addressing that complaint, we discovered that they didn't have legal right of entry across the landowner's property because of the land change that had occurred. And thus we're here. So Pat Farr himself has been a diligent operator.
And so we've established that the existing bond is adequate to do for reclamation. And just to clarify here on the record, should we even decide to assess a civil penalty and call it $10,200, that is not money that goes towards reclamation, correct? That goes towards the general fund and cannot be used anyway. So we're not taking away from resources to do reclamation if we choose a different amount for the civil penalty.
Correct.
Any other discussion? Ms. Stiegelmeier, do you have any questions on the line?
Thank you. No questions. I followed. It's quite complicated. And I appreciate all the comments.
Okay, just want to make sure you.
Yeah, I can go ahead and make a motion, Madam Chair.
Yeah.
I move to accept that the board accepts the staff recommendations as written, excluding one stipulation of waiving the remainder $10,200 civil penalty. And that's it.
Second. Sorry. Second by Nelson. Any discussion? Okay.
Yes.
We are in the middle of a motion, Mr. Farr, so we can't hear more from you, but all those in favor, please signify by saying aye.
Aye.
Those opposed, same sign. Hearing none, the motion passes. Thank you very much to all of you. We appreciate Mr. Farr being on the line with us, and I'm sure that the division will continue to be in contact with you for the additional items moving forward. Thank you. Okay.
Yeah.
Fill up. Okay, we are moving on to item number 6. This is the formal public hearing with Grand Island Resources LLC, file number M-1977-410. Mr. Lindbergh, again. Okay, do you have anyone here, operators in the room that also need to be sworn in? No. Do all of you swear to tell the truth?
Yeah, Daniel
I do.
Takami is representing the operator.
I see you, Mr. Takami. Thank you. Okay, so we'll hear from the division on this one.
Sergio Rivera for GIR.
Okay, and you're also
Like
here on behalf of the operator?
Yes.
Oh, okay. Is there a third?
And then there's a third.
Yes, ma'am. Sean Paul Brewer.
Brewer?
Yes, ma'am.
Rivera?
So just so you know, Sergio Rivera is our leader of our technical team, and then JP Brewer is their mine manager at the Grand Island Resources. I'm the president.
Thank you very much.
You're welcome.
Okay, so same kind of protocol as the previous one. We'll hear from the division, then we'll hear from the operator, have some discussion and move from there. So, Mr. Lindbergh.
All right, my name is Patrick Lindbergh. I'll be representing the division in this matter. This matter is for consideration of the operator's request to extend the due date for submitting the designated mining operations application. This is for the Cross Gold Mine M-1977-410 operated by Grand Island Resources. This is a 110-2 hard rock underground mine permit currently. It's located approximately 4 miles northwest of Nederland, Colorado. The permit area is 9.99 acres. They're mining for a variety of metals. The land ownership is private. The current financial warranty is $546,751. It is currently adequate. Here's a map. You'll see Nederland there in the lower right-hand corner and the Cross Gold Mine northwest of there. Here's a brief site description. The permit area includes 2 discharging mine openings: the Cross Mine portal at the Cross Mine and the Idaho Tunnel portal at the Caribou Mine. Discharge is directed to a series of plastic-lined ponds prior to being treated and discharged into Coon Track Creek at a permitted discharge point. Water treatment consists of filtering water through a series of 5-micron filters to remove total suspended solids, and then the water is treated through a polishing medium to remove total dissolved solids prior to discharge to Coon Track Creek. The operator collects groundwater and surface water samples monthly and submits the results on a quarterly basis. Sampling consists of 3 monitoring wells, 2 surface water locations, up and down gradient of the permit boundary, and 2 mine portal effluent locations. Here's a map of the site. The red boundary is the permit boundary. And you can see the ponds that are used for water treatment. The water treatment facility is the yellow box, and then the 2 mine portals. Here's a brief chronology that kind of gets us here today. On September 21st, 2021, The division received notice of non-compliance from WQCD for zinc, cadmium, lead, copper, and silver exceedances at the permitted discharge point. On October 1st, 2021, the division sent the operator a reason to believe a violation exists and notice of board hearing letter for failure to minimize disturbances to the prevailing hydrologic balance of the affected land and the surrounding area, and to the quantity or quality of water in surface and groundwater systems, both during and after during the mining operation and during reclamation. February 18th, 2022, the board issued its order for MV 2021-017. The board's order issued a cease and desist order for the site and contained corrective actions. February 17th, 2022, the division sent the operator notice of the designated mining operation determination. March 18th, 2022, the operator submits an appeal to the division's DMO determination. June 13th of 22, the division issued its final DMO determination. July 13th of 22, the operator submits an appeal to the division's final DMO determination. The hearing for the DMO appeal is continued multiple times at the request of the operator. On January 10th, 2023, the operator enters into an agreement with the division, dropping their appeal, and agrees to the division's determination of DMO status. On January 18th, 2023, the board hearing for whether or not to lift the cease was the date for whether or not to lift the cease and desist order. Additionally, this is the date that begins the 180-day period for the operator to submit the DMO application. February 16th, 2023, pursuant to Rule 7.2.3 parent 2 parent C, the operator requests an extension of the due date to submit the DMO application from July 17th, 2023, the 180-day due date, to January 18th, 2024, the 365-day due date. On March 1st, 2023, the division approves the DMO due date extension request. December 22nd, 2023, the operator requests a hearing before the board to extend the due date for submitting the DMO application for another 365 days. Designated mining operation application submission. Rule 7.2.3 dictates the time frame for submitting a DMO application for an existing operation. Rule 7.2.3 parent 2 parent C states, within 30 days of a DMO designation, request a period longer than 180 days, not to exceed 1 year, to file such plan based on a demonstration satisfactorily to the division that additional time is needed to prepare an environmental protection plan. The division agreed to a 1-year extension to submit the DMO application. However, there is no guidance in the rules if another extension beyond the 1-year time limit is requested. Therefore, the matter is before the board today to decide. Staff recommendation. Division staff supports the operator's request for a 365-day extension to the due date from January 18th, 2024 to January 17th, 2025 to submit the DMO application. If the operator cannot submit the DMO application by the new due date, staff recommends A, if the operator fails to submit a complete designated mining operation application by January 17th, 2025, no additional time will be granted. The end of life of mine will be declared, and the operator shall immediately cease the mining operation at the site and commence reclamation as required by the current permit and in accordance with Rule 3.1.3, parent 2. And or B, if the operator does submit a complete application by the January 17th, 2025 deadline, but fails to obtain approval of the application within the 365-day deadline approved or provided by Rule 1.4.1, parent 9 for applications, no additional time for review will be granted. The end of life of mine will be declared, and the operator shall immediately cease the mining operation at the site and commence reclamation as required by the current permit and in accordance with Rule 3.1.3, parent 2.
Questions?
Just a comment, it seems like the division has set itself up for dealing with either situation like as it comes, essentially.
That is correct.
Okay, thank you.
Okay, those of you on the line from the operation, if you, oh wait, a question from Karn, yeah.
Yeah, I'm just wondering about all of this sitting there, and what about water quality issues? There's not mining going on, but is there continuing cleanup of the wastewater? Or what's the status there?
So the operator is currently collecting both surface water, groundwater, and effluent samples on a monthly basis and reporting those water quality results to the division on a quarterly basis. Currently, there are no exceedances of Regulation 41 standards, except for a couple of hits here and there, but they're borderline on some things. But their discharge permit, where everything is, where their mine effluent is going, they have had no exceedances of their permitted discharge permit.
Since that last exceedance that you noted.
Yes.
And just to let the board know, we inspect the site on a quarterly basis. So Patrick's up there every quarter inspecting the mine site. We're in good communication with the operator. They submit quarterly reports to the board that we then submit to you guys every quarter, explaining what activities are occurring at the site, if any. And so, you know, we're keeping a pretty close eye on them, and they're also, you know, informing us of their day-to-day activities, essentially.
Okay, we'd like to hear from the operator if you have anything to add.
Sure. Good morning. Can everyone hear me?
Yes.
Okay, great. Thank you so much. My name is Daniel Takami. I'm the president of Grand Island Resources. I thank everyone for taking the time to consider our DMO extension request today. Something that I would like to kind of clarify. We had 5 quarters of quarterly baseline water data testing that needed to be completed, which is 15 months. So that took some time, and this was the issue before we could get our environmental protection plan completed. The water testing, that the 5 quarters of water testing was just completed in December of 2023, which was the end of last month. Now that that is completed, we can start on our environmental protection plan. That being said, that environmental protection plan cannot be started until, unfortunately, because of the snow and ice up there. So as soon as spring hits, we'll be able to get in there, complete that, and then that information will be able to provide for our DMO, or designated mine operation. So part of this was, it was delayed due to our water testing that was required for 5 quarters, which is 15 months, and which we have done and completed. We've been very transparent with everyone, DRMS and so on. And so, you know, we appreciate that. And this is the steps that we had to take as a company to fulfill the requirements. So now that we have completed the water testing and the baseline testing, we will be able to complete our environmental protection plan and then our designated mine operation application. Does that all kind of make sense?
Yes. just based on elevation, you know, the definition of spring can be pretty variable around here.
Absolutely.
You know, are you comfortable with that timeline of January 17th, 2025? Obviously, that's not really a true 365 days once you kind of can get back up in there, but comfortable with that?
That's the reason why we requested that, so
Okay.
we could have the summer to complete it. You know, like you said, it's not a full year, and asking for a full year really only gives us 6 months, as you know.
Okay. But that math is kind of behind that, knowing that you really are
Understand. Yes, we
hitting the
understand.
ground at the moment. Okay. Anything else from the operator? Any questions for them, from the board?
No, ma'am.
No?
Yes, this is Sergio Rivera. I do have a question regarding the recommendation by staff in that there is no additional extension after the DMO application is submitted in the case of the application being rejected by DRMS. My opinion at the moment is that that is going to preclude the mine from potential continuance should DRMS find deficiencies with the submittal of the application, as was just now discussed. The operator would only have 6 to 7 months to complete the DMO application and the environmental protection plan. So I would request that the board considers that the taking over and not allowing an extension to the DMO application beyond the terms of 1 year should DRMS find deficiencies in the submittal. I would ask the board to reconsider that recommendation by staff.
Do you want to clarify that, Patrick, how that would work?
So I'm unclear
I
exactly.
think it was about item closer to B on those two and or.
Yep.
And it was kind of saying, so I guess maybe just a clarification, if they've got their designated mining operation and they're kind of working through the application. Say if you guys send the application back and you need some more clarification. Does that fall within the 365 days too? So they have to have the whole thing buttoned up
Yeah,
and
so
approved by January 17th
of 25?
of 25?
No.
Yeah.
No, once they submit the DMO application, then that sets, by statute, they have a whole year, another 365
Okay.
days. So we'll have a full year of back and forth as needed to get it approved.
I think the concern was that like, essentially it could put it in your court and he just wouldn't have any control
Oh.
over that. So Mr. Rivera, do you understand that there's sort of two separate timelines? I don't know if you can go back to just that parent B on the two.
Yes,
options.
yes, I do understand.
You got that? Does that,
it is,
does that help you?
Yes, so we have, the company has 365 days to submit the DMO application and all pertinent documentation. And then there is 1 year of revisions and updating should deficiencies be found.
Yes.
So it is not
Correct.
that. Correct, I understand. Thank you very much.
Yeah, the standard back and forth of the application process. So that's a good point of clarification. Thank you.
Madam Chair, if I
Yeah.
could also, there's more than likely a chance and stuff in that when the application is submitted and stuff in that, we have stakeholders and stuff that will be involved. So that approval will be in front of the board. So it won't be a staff decision, it will be a board decision at that time. So we go through our review process, we'll look at objections, comments and everything else, take those all into account. And then from that point, it will come back to the board and stuff and that, but we're correct. So when they submit the application by statute and stuff, that creates a 365 day.
Right, we'll be back on the application clock as opposed to right
Yes.
now, we're in DMO, environmental protection plan
Yes.
clock. At the moment, trying to get that going and then it'll restart with the normal
Correct.
application. Okay, great. Other questions from the board? Okay, hearing none, with that, we will close testimony, for lack of a better term, and Is any discussion from the board on the matter in front of us? Would it be helpful for him to put the staff recommend, can you put that slide back up? Just so we can. Please. Yes, great, thank you.
Now, this is Daniel Takami, and the only question that I do have, and I'd like to just bring this up. It says if the operator cannot submit the DMO application by the new date staff recommends, no additional time will be granted. We fully expect to have it completed well before January 17th of 2025. The fact that it says no additional time will be granted and the end of the life of mine will be declared, that's pretty final. And it would be nice if, I mean, we absolutely intend to have it done, completed well before the January 17th, but say there was a COVID, for example, something that beyond our control. I'd hate for it to be so final and something happened that we can't even control.
Very, very closed doors and a lot of variables that are outside of our control.
Vision, have any comment on that?
Yes, I do. We made our initial designation almost 2 years ago.
Mhm.
And they made these very same statements that, oh yeah, we'll be able to get it in within a
Yeah.
year. And they fought us on the appeal. They eventually withdrew it. Then back a year ago on January 10th, they agreed that they would be able to submit the DMO application within the time frame that was originally required. And here we are again, and they are asking for another 365 days. The permit they currently hold is not sufficient. They need to be a DMO. If they can't cross that finish line, they need to be done mining.
I'm sorry.
If, for instance, we proceed with your recommendation and something catastrophic did happen, could we revisit it at that time?
Sure, I would imagine the board would entertain a request from them.
Okay, thank you.
Okay, I appreciate that. Thank you.
Um,
Yeah.
Make a motion to follow the staff's recommendations to grant another year for the submission to the DNO according to the staff's very nice language. Can't read it,
Second.
I can't read it.
Second, any discussion? Okay, all those in favor, please signify by saying aye.
Aye.
I,
Those opposed, same sign. Okay, hearing none, we will grant the operator's request to extend the due date to submitting the DMO application to January 17th, 2025.
Thank you so much.
Yep.
Thank you to the board.
Thank you all for being here. Thank you for your time and
Thank
to
you.
the division for all the information and due diligence and quarterly check-ins. I would like to make a motion. I'm open. We take a quick break. 10 minutes. Does that sound fair for people? For those of you on the Zoom call, please be logged back in by 10:25 a.m. And because we'll just mute the microphones and everything so people can wander around. Okay,
By light pollution.
just a quick sound check for those of you on Zoom. Can you hear us okay? Yes, great, thank you. Okay, we are on item number 7. This is a board action, Tallahassee Resources LLC, file number P 2023-15. Consideration of appeal for DRMS decision to approve an NOI. Before we get to that, well, actually, first let's swear everyone in so that we know who we have here. So those of you who intend to testify, division, operator, objectors, everyone who swears to tell the truth?
Yes.
Yes?
Yes.
Okay, great. So before we get to this, we have a motion to strike that's on the table here. I think if this works out, I'd like to hear maybe from the applicant 5-ish minutes about this motion to strike, and then allow the objectors to weigh in on that. Then we'll have some board discussion about this initial motion to strike, if that's okay. And just as a reminder, we have our court reporter here. She's on Zoom. Typically, the microphones are pretty good, but if I ask you to speak up, if I ask you to spell your name, definitely if we're kind of going back and forth, just get in the habit of stating your name when you're speaking. It just really helps her job, you know, taking notes down. Thank you.
Thank you. Thank you, Madam Chair and members of the board. My name is Joe Middleton, and I am Tallahassee Resources outside counsel. And as requested, I'll address our motion to strike. I think there are kind of 2 categories of items that we wanted to limit in terms of their entry into the record today. That would be the letters that were submitted as an exhibit by the appellant, and also the proposed testimony of Mary Jane Sisson. Let me start with Ms. Sisson first. I think our position, after having discussed the matter a little bit more with the appellant, is that we understand she's not intending to testify as to any matter that would require expert knowledge or, would stray outside the bounds of her own personal knowledge. And so at this point, we don't have any objection to testimony on, as long as it's constrained in that manner. We, of course, would want to reserve the right to object if she testifies as to matters that are really more proper for an expert witness. So that's our position at this point in time on that issue. With respect to the letters in question, our primary concern is that they really constitute public comments. There's a public comment process and a timing for public comments. And I think one of the major reasons for that process is so that both the division and an applicant can address the matters in those comments before a decision is made on an NOI or a mining application or whatever it might be. In this case, though, those comments were solicited specifically in support of the appellant's position rather than in relation to the actual NOI itself. But they do clearly relate to matters that could have been addressed earlier if we'd had the chance. And so I think just as a matter of substantive fairness and to adhere to the rules and give the rules their effect and their intended purpose, I just don't think they're properly admitted. And I think certainly the appellant's witnesses are capable and able to testify as to those matters to the extent they should be before the board. The other thing I would say is that much of the comment in those letters relates to non-jurisdictional matters, really, issues that arose during the county use proceedings, use permit proceedings, or issues related to a homeowners association, or things that the board doesn't have jurisdiction over. So by and large, I don't think they're necessary to consider anyway.
Thank you.
Any questions? I'm glad to answer.
Any questions? Thank you.
Okay, thank you.
Would the objector, Mr. Parsons?
Sure, thank you. Jeff Parsons on behalf of the appellant. I want to thank counsel for the applicant. We did have a discussion about Ms. Sisson, and I agreed that she's testifying as a fact witness, and I think that resolves that issue. As far as the letters, those are not being submitted as in an attempt to qualify those as as formal public comment or to have those authors be parties to this proceeding. And there was no dispute as to their truth or accuracy or their true and accurate copies in terms of sort of strictly from an evidentiary point of view. That wasn't at issue. Our use of those letters at this proceeding will not be as to their substance. The fact that they relate to issues that could have been addressed by the division in the comment period sort of gets to our point that they, by and large, didn't have notice and didn't have feel that they had a real opportunity to submit those comments. So that's sort of the thrust of the use of those letters, is that there are a whole raft of people in those communities that are interested and wanted to be engaged and felt like they didn't have that opportunity because of the difference between the very short prospecting public comment and public notice versus the mining operation permit public notice procedures. And so that is more or less the thrust of the use of those letters, not for their substance. And so I think use for that purpose is appropriate.
Okay. Just a question maybe for the division, because we have spent a significant amount of time in the last couple of years talking about notice periods, talking about public being aware of something. I guess just a question. Essentially, you're saying that there's a chunk of people who really were part of the public comment period and awareness piece, but then
I'm sorry if I can clarify.
Yeah.
I'm saying that these are people who have a direct interest in this matter, as evidenced by the letters, but felt that they did not have a proper opportunity or a sufficient opportunity or knowledge even of the project in order to weigh in a timely manner to be considered timely and relevant comments for division consideration. That's generally the thrust. I mean, they submitted them once they found out about the application, which came effectively through the county process, which was much later and way past the deadline for submitting timely comments to the division, is my point.
This is Russ Mange for the division. The act and the rules and stuff are really quite clear and stuff, and that NOIs are a very short time period and stuff because they are at a very different level than a mining permit.
Yeah.
And that, so, and as you know, this issue and stuff has been coming to the board and stuff and that, and divisions looking at different avenues and stuff to increase those kind of efforts and stuff on that public notice and stuff. But I think council and stuff and that will recognize and stuff that it was done by the act and the rules. And it's unfortunate and stuff that some people miss it, but no matter where we draw a line and stuff, there'll be other people on that other side. The other part of that too is even though those comments and stuff, we get a lot of comments and stuff after the period, that does not necessarily mean that we dismiss them totally. We take a look at those and stuff when we have the opportunity and to address them, which is what the applicant's attorney was pointing out, and that is is that they would have had an opportunity to address those if they had been submitted and stuff to us and stuff. So in all of that and stuff, it's just we follow the rules in the act and stuff and that as they are today.
Yeah. Okay, so any discussion on the board here for this motion? I think that we have a couple options. You can either approve it, you can deny it, you can grant it in part or in whole, based on what we've heard here, what we think is most relevant, jurisdictional to the matters at hand. I think we got some good clarification, and I'm glad you two were able to talk and, hear some of those things.
Madam Chair, I think that this board has leaned towards being more open to and inclusive of public comment. And so I would be fine with denying the motion and proceed.
So you're in favor of kind of denying the motion in whole, being able to at least have those letters as part of the record, and then also allowing Ms. Sysom to testify.
Yes, with the understanding that.
You're having some trouble with the connection. Please try again in a moment.
That the testimony should be to our jurisdiction.
Right. To her jurisdiction as a neighbor, not as an expert witness.
And
Relevant, yeah. Any other thoughts on what kind of direction Mr. Mock is proposing here? Do we have a motion?
So moved that we deny the motion as long as testimony is relevant and as a witness and speaks to our jurisdiction as a board in this matter.
And I think I would just amend that, making sure that the applicant reserves the right to object as well. I guess obviously the applicant, the objector as well.
I would accept that as a friendly amendment.
Okay. Second by Nelson. Any further discussion? All those in favor signify by saying aye. Aye. Any opposed, same sign? Okay, so we will deny the motion to strike. With that, so as a matter of process here, I think what we'll do is we'll have the division kind of set the stage for us. I believe Mr. Fugate will be, or no, Scott Schultz, I'm looking straight at him. Kind of set the stage for us, then we'll hear from the applicant, and then we'll hear from the objectors. Again, you know, I think we have a lot of information in front of us. I do not have set time periods, but I will just say that if something is getting very repetitive, if somebody has already said something 4 times, I am going to cut you off. It's becoming non-jurisdictional. If we absolutely know that something is a matter that is not within the board's purview, that's falling under a county or whatever, I know that people can get very emotional about some issues, but just if I say we're not going to talk about that because it's non-jurisdictional, it doesn't mean we don't care about that. It means that no matter what, doesn't matter how long you want to continue talking about it, that's not something we can do something about. So just putting that out there, and I will remind you if we get to that point, things get really repetitive. Okay. All right, Mr. Schultz.
Thank you, Madam Chair. While Mr. Kazir is setting up, I'll kind of try to provide a little bit of the parameters. My name is Scott Schultz. I'm an attorney with the Colorado Attorney General's Office. I represent the Division of Reclamation, Mining, and Safety. In this matter, I believe that the division is staffed to the board in the appeal of the application of notice intent to conduct prospecting. I have spoken with Mr. Parsons and Mr. Middleton roughly about the timing and the order. We have agreed roughly 1 hour per side for both the presentation and the rebuttal. The order that we have agreed upon, again, obviously subject to change by the board, was that the division would provide its presentation first. The objector would go second for the presentation, and then the applicant would go third. In terms of the rebuttal, we were going to change the order a little bit. Division would go first in rebuttal, but then the applicant would go second, and then the objector would go last for rebuttal. Part of that is because the objector does have the legal burden in this matter. Mr. Middleton obviously would like to reserve his rights, and I'll let him speak to that. But in case anything comes up in rebuttal that was new, he wanted to have some opportunity to rebut that. So I'm not going to comment on that. We'll just deal with it, I think, when it comes up.
And you did say an hour each, including rebuttal.
Correct.
Presentation.
Total time per
time
party.
for each party. Okay.
I think we can adhere to that famous last words, but I
Yeah.
think we're ready to do that. And with that, I'll turn it over to Mr. Kazir.
Thanks, Scott. My name is Tim Kazir.
Excuse me, representing the division in this matter. And a lot of members of the board are new faces to me. I'm sure I'm a new face to you, so and introduce myself. I'm a registered licensed professional engineer in the state of Colorado. I have a undergraduate degree in aerospace engineering, a master's degree in civil engineering and water resources. I've been 27 plus years of mining experience, 14 plus in consulting, and a little over 13 here with the division. And I cut my DNR teeth or DRMS teeth on NOIs, working with several dozen NOIs trying to get them into compliance. So I'm pretty familiar with the NOI process and the rules. That introduction, I'll go ahead and get started. This is a prospecting application from Tallahassee Resources Exploration LLC, file number P2023015, appeal by Skip Blades of the division's decision to approve. The division's presentation includes a summary of the staff review. Summary of the application, the prospector is Tallahassee Resources LLC. The purpose is to investigate a uranium deposit. All the affected land is on private owned land. The bond calculated by the division and received and approved is $115,568. The location is a remote area of central Fremont County, about 30 miles northwest of Canyon City. Here's a map showing the area. Just for reference, up here is Coral Springs, over here's Pueblo, Canyon City is highlighted, and the big white arrow points to the area that's proposed for the prospecting. I've got a chronology slide here. It's in your board packet. Just make a long story short, we received the application on July 5th of 2023, and we approved or sent a notice of our decision on November 14th and received the appeal on November 21st. If there are any questions about that, I'll be happy to go into it, but just skip forward in the interest of time. So application overview, the proposed prospecting method is core drilling, which is a common method for hard rock. They're proposing 25-inch diameter holes about 700 feet deep. Part of that will include a solids removal or solids recovery unit, SRU. This instrument captures the excess drilling fluids and cuttings and recirculates the clean fluids, segregates cuttings for off-site disposal. It results in it's a closed loop system with zero discharge, so there's no drill mud pits or fluid sumps, and it reduces water consumption, and there won't be any waste piles. Application overview, surface disturbance. Everything's going to be reclaimed. They're proposing about a half mile of new trails. These are not roads, these are trails, just to make a distinction. And upgraded trails about 3/4 of a mile. There'll be 20 level drill pads, about 80 feet by 80 feet. Minimal grading disturbance. Sites will be located on level terrain as practical. This eliminates dirt work to level, preserves the native vegetation and topography. Drill pads will be leveled only when they're located on a rough terrain, and it avoids mature tree stands. This is a map of the proposed drilling locations. The green lines are trails to be upgraded. That's in that roughly 3/4 of a mile total. The orange lines are new trails, which is about a half a mile in total. Back to the application overview, the equipment for prospecting will consist of a surface air mud rotary drill rig, a diamond core drill rig, the solids removal unit, an air compressor, water and pipe trucks, backhoe, grader, and dozer for trails, drill pads as necessary, and pickup trucks and light plants. This is a typical drill setup. This is not this site, obviously I haven't started yet, but you can see this one, they're set up to drill. There's no drill pad. My experience in the last several years, drilling has become much less invasive. You can just drive the truck in, set up a rig, drill it, and when they drive away, there's maybe a small and a couple feet in diameter that you can see there's a disturbance. This one has a water tank over here on the right, and there's a water truck in the background, so it doesn't have the solid recoverable unit, but this is typical of what you'd see with a drill setup. A little different angle shows the drill rod on the trailer here. Just for some members of the board may not be familiar with what a core looks like, but it's just a cylindrical tube of rock that they pull out with a drill. So it's kind of what it looks like. So on the individual hole timeline, pull up, set on the pad, it's about half a day. They drill about 550 feet through overburden, which takes about 3 days. Then drill about 150 feet of the mineralized zone, which will take about a day. Run a gamma survey, and then abandon the hole about half a day. And so the total time on per hole per site is about 5.5, 6 days. Proposed chemicals include bentonite cement for hole abandonment. That's key. Diesel fuel, they're not going to store it on site. It's transported to the site in pickup trucks used by the drill crews. It's transferred each rig each day. Drill fluids and lubricants, and then petroleum products stored on site in leak-proof secondary containments. Tubs. From a reclamation plan, the two key components here are borehole abandonment and revegetation. So part of the NOI requirements are proper borehole abandonment process to prevent cross-contamination or cross-aquifer contamination here. Then NOI revegetation is held to the same standards that mine reclamation permits are. And then the reclamation bond is calculated in the same manner as in mine reclamation permits. The equipment for reclamation is similar. You get the same drill rig to tremie the cement that night into the hole. You got air compressor, water and pipe trucks, backhoe grader, dozer is needed, plus a seed drill for seeding and pickup trucks. Yeah, this is the borehole abandonment is key to what's being proposed here. NOI requirements are much more stringent prescriptive than they are for the mine reclamation permits. So it includes any drill hole which encounters an aquifer and consolidated rock formations, which is what's expected here, shall be sealed utilizing high quality sodium bentonite type gel, specifically developed for use as abandonment fluid or an equivalent material per rule 5.4.2 parent 2. And then the other key component of this is no later than 12 months after the completion of the abandonment of any non-artesian drill holes, the prospector shall submit to the office a final report containing a description of the plugging, sealing, and capping techniques used pursuant to rule 5.7 parent 1. Now the method of abandonment mirrors DWR's requirements for when water wells are drilled and abandoned. And then as far as the submittal of the completion reports, the DRMS will review those and make sure all the I's are dotted and the T's crossed. So the proposed borehole abandonment, from what is in the NOI application, holes will be immediately abandoned in accordance with rule 5.4.2 after extracting the core and collecting data. The abandonment reports will be submitted to DRMS within 12 months. They're going to submit the bottom 70% of each hole or to the top of the mineralized unit, whichever is greater thickness. So that'll help prevent any cross-aquifer contamination. Bentonite will then be used above the cemented portion to fill the remaining depth of the hole. Then a surface cap will be stamped with the drill hole number. And this is key because of the minimal disturbance here. It can be sometimes difficult to find these holes when we're looking at final reclamation. So if you have a cap there when you go up a year or so later after re-veg, you can find it and just be assured you're in the right spot. As far as proposed site reclamation, the drill cuttings will return to the hole as much as possible during hole abandonment pursuant to rule 5.5.2 parent C. If disturbed, the drill pad and trails prepared for will be prepared for final reclamation by ripping the surface and replacing the salvaged topsoil pursuant to rule 5.5.2 parent D. And the seed mix is a diverse seed mix that includes western and stringbank wheatgrass, blue and side oats grama, as well as green needlegrass.
Can I just ask a quick question there?
Sure.
So the drill cuttings, that's like the overburden drill cuttings?
Correct.
And so are you doing that? Because essentially like that timeline of the 5.5 days, you're doing that concurrently with the abandonment of the hole? Like,
Right, so after they pull the core, run the gamma survey, then they'll have, some of the cuttings will be available for backfill.
right,
As their own.
you keep what you know is kind of part of like assays or whatever, but then
Right.
this whole, anything you know is overburdened, you put that back down into the hole, but then you're kind of capping it.
Correct.
Okay.
Yeah. Our reclamation cost estimate included the abandonment of 20 boreholes. That's about 72% of the total direct cost. And the disposal of the solids recovery units off-site, about 15% of the total direct cost. And there's the rest of the bond is made up with the grading and ripping of the pads and trails, seeding the pads and trails, and then mobilization, demobilization equipment from Canyon City. Because this is a more extensive site and got 20 different holes, I also add in an element for intrasite mob and demob to move equipment in between the different drill sites. So as far as the appeal objections, there's a summary here. There's some visual noise impacts, which are non-jurisdictional for the division. Hydrologic balance, risk of water contamination, wildlife impacts, and then prospecting versus mining. I'll just go into those, to how those were addressed. From a hydrologic balance standpoint, the risk of water contamination, as alluded to earlier, each drill hole will be open for less than 6 days. The mineralized zone for each hole will be open for less than 2 days, and then it will be abandoned. There's a zero discharge process because of the solids recovery unit. Drill fluids and all will be contained in mineralized solids removed. From a surface standpoint, straw water will be used to prevent topsoil and gravel from washing into any drainages from precipitation events. And then, as you know, it's key with this type of operation, the borehole abandonment required by Rule 5.4. Wildlife impacts, they alluded to impacts on the local population. And as previously recommended by CPW, they recommend to conduct the drilling operations during a 60-day window between May and December to avoid impacting the resident big game animals, excuse me. The operation will be a 24/7 schedule with personnel on site, and they'll complete the job as quickly as possible to minimize disruption. And again, the drilling will be a zero discharge process to avoid any loose fluids as being a wildlife attractant for drinking water or what. Prospecting versus mining. There are 7 definitions in our rules that get pretty lengthy, but these are what we consider when we're determining whether this is a prospecting operation or a mining operation. So prospecting pursuant to Rule 1.1, Parent 57, development per Rule 1.1, Parent 20, production per Rule 1.1, Parent 56, extraction per Rule 1.1, Parent 23, mining operation pursuant to Rule 1.1, Parent 41, affected land per Rule 0.1, Parent 4, and extractive metallurgical processing for Rule 1.124. In conclusion, the proposed prospecting activities are consistent with typical hard rock prospecting programs that we have all over the state. The adverse impacts to wildlife are minimized as required by Rule 5.3.2. Disturbance to the prevailing hydrologic balance of the affected land and the surrounding area, and the quality of water or quantity or quality of water in surface and groundwater systems are minimized as required by Rule 3.1.6, Parent 1. Boreholes require abandonment pursuant to Rule 5.4, and analyze in compliance with the Act, rules, and regulations, and the prospector is required to comply with all applicable local, state, and federal laws as required by Rule 5.3.6. Staff's recommendation, based on our review, Tallahassee Resources prospecting application submittal adequately addresses the rules and requirements of the Act. Staff recommends that the board deny the petition for appeal and from the office's decision to approve the Tallahassee Resources NOI file number P-2023-015. Any questions?
Any questions? Okay. Thank you both very much. So we will hear from the objector next, based on the order given. For those of you on Zoom, we're just pulling up the presentation, which is always the easiest part of this whole thing.
Yeah, exactly.
Thank you. Thank you. Members of the board, my name is Jeff Parsons. I'm attorney for the appellant, Skip Blades. This is Mary Jane Sisson. She's a witness. Let's see, is this projecting?
It's not projecting. Oh, is it there? Okay. So I guess that's fine.
Can you help?
Why it's not?
Yeah. I could try, but I might
Yeah,
use even
okay.
this
Thank you,
portion.
I appreciate it. Thank you.
There we go. Hang on.
Thanks for your patience. We're here today to appeal the approval of prospecting permit 2023-015 for the Tallahassee area. This is a site of mining deposit and ore deposit that has been before this board before. As you read from our objection, in 2015, virtually this precise issue was before this board as to whether further drilling into this deposit is appropriate as a prospecting permit or should be permitted as a mining operation. And the board at that time found that it was not prospecting, but development. I put up some of the, I appreciated Tim going through some of the, noting some of the definitions. And this is really going to be the key for the board's consideration today, are the definitions of mining operation and development. Those are really the critical aspects. And of course, a mining operation includes development or extraction. So I just wanted to clarify for the board that just because you're not actually extracting minerals doesn't mean you're not in a mining operation. It also includes the development phase. And development is defined, excuse me, rather broadly by the Act. It means, as it states on the screen, the work performed in relation to a deposit following the prospecting required to prove minerals are in existence in commercial quantities. And as relevant here, it includes activities such as defining further the ore deposit by drilling or other means. And so as soon as you have a demonstration that minerals are in existence in commercial quantities, any additional drilling into that deposit to further define the ore body is development, and therefore subject to the mining operation permit and not a prospecting operation. You'll hear today what I believe are extraneous arguments that there's no mine plan yet developed. Well, this definition of development does not require a mine plan to be developed in order for to be on the table for development to have occurred. In fact, in the board's prior ruling, that also wasn't the case. There was no mine plan proposed at that time. You'll hear that there are stock exchange, international stock exchange requirements for how they report their materials, how they report their resources. Those are also not embodied into Colorado law. And I would submit that relying on a stock exchange perception to interpret Colorado laws is a flawed process. In Colorado, as soon as you have proven minerals are in existence in commercial quantities, you're past the prospecting stage. And there's and so the board had dealt with this issue in its November 2015 board order dealing with this precise same deposit. And these are some of the relevant, these are the paragraph numbers in that order. It is in your board packet at pages 308, 309. So you have it in front of you. And the board, and these are quotes from the board order, that the testimony and evidence presented at the hearing showed that the applicant had conducted extensive exploration through drilling core holes and feasibility studies and proven that commercial quantities to show that commercial quantities of uranium exists. Talked about press releases, and you'll see the same thing in this instance where you have the company issuing these stock exchange press releases and then saying one thing, that we found these, that we have this much ore in this ore body and it's going to be commercial, yet coming to this board and saying, no, we haven't done that. We still want to go through the prospecting. And there's a good reason for that, because the prospecting permit is much easier to navigate, obviously. Again, the applicant at that time talking about the mineral resource estimates that they have for that ore body. These are the same estimates that are being used. They use a different cutoff grade so that different companies can estimate different amounts, but it's the same data. They're using the same data that prior operators had. This site has been explored and drilled since the 1970s. In fact, there were active mining operations on this ore body in the 1970s. And so the board's ruling, of course, was that any work to further define that ore body at that time, because of all the work that had been done in the past and all the demonstration that there is a commercial ore body there, any further work on that ore body constituted a mining operation and not a prospecting. So these are examples not from the previous operators, but from this operator's information that was submitted both to county and this division. And you'll hear a little more about this from Skip. But you can see the detail that they're providing demonstrates that there has been extensive, and they admit there's been extensive drilling and work on this ore body to demonstrate that it is a commercially, that the ore is in commercial quantities. And they talk about how they will, and I think this is relevant. The approval, and this is the county permit they're talking about, the conditional use permit, but it's the same project. It will allow a copy, which again, I think for ease, I'll refer to them as Okapi because that was the name on which they submitted the application. I understand there's been some changes in their corporate name, but with your allowance, I'll just use Okapi for shorthand. This will allow them to advance technical work and complete a focused drill program at Hanson to supplement the significant existing data on the project. So this is where we're showing that this has gone beyond trying to find this ore body, and we're now into what it defined as development, further defining the ore deposit by drilling or other means. And that's why we're in development stage at this point. New drilling, again, quoting from their annual report, this is Exhibit D as we submitted. New drilling will be designed and located to test critical areas where additional data is required to rapidly advance mining studies. So again, further defining the ore body. We're not looking for the ore body. We found it. We're now doing essentially the delineation drilling in order to fine tune the mine plan rather than demonstrate that we've got commercial quantities. Moving forward, again, in the county permitting process. This is the county's planning staff in the minutes. They, referring to a copy, have filed a notice of intent with DRMS for permission from the state and the subsequent reclamation of bonding requirements to go along with that. The purpose of this project is they need to know more information about hydrological, meteorological work, more geochemical work, more technical work, and environmental work. What you don't hear here is they need to find an ore body. They found the ore body. And in fact, that's demonstrated by the planning director quote from the minutes of the planning commission, where the planning director testified to the planning commission that Tallahassee Resources has submitted the application to conduct mineral exploration activities to further delineate the known uranium deposit and collect data that will guide development of an environmentally responsible mining technique. Again, what we're dealing with is within the county permit process and within their stock disclosures, they're professing that they found a commercially viable ore body, and now they just need to do the fine tuning and the delineation drilling in order to figure out the mine plan. That is well past the prospecting stage as defined in Colorado law. We're now into the mining development, and it matters. As you'll see, and as you probably know, mining requires, this is particularly with respect to the local residents. I mean, this is a residential area we're talking about. And so notice is really important. For a mining operation, you have a whole set of processes that are intended and designed to make sure that all the neighbors are aware of what's going on. Publication in the paper, prominent posting on the DRMS website. I will note that the NOIs have to be posted on the website as well, but there's a distinction. Mining operations have a special page where you can go and click and see what's new, essentially what new activities occurring, and you see the mining operations. You don't have no prospecting notices show up there. For those, you have to dig through the actual files within the database. I will submit to you that it's a more complicated process to figure out if someone submitted a prospecting operation and if someone submitted a mining operation. Going further, large signs at the site, notice to adjacent landowners, placement of the application at the county clerk's office, notice to the conservation district, and at least a 1-month comment period. Those comment periods go 20 days following the last publication in the paper. So it has to be for multiple weeks in the paper, and then upon the last publication, you then have 20 days after that. So it's a more extensive period. Whereas, as was addressed a little bit, or at least referenced a little bit earlier today, the prospecting under Rule 5.1.3, they're posted in the database, and that is virtually it. And it shouldn't surprise anyone that you usually have less attention or less knowledge of a prospecting operation than you do a mining operation. And some of that is appropriate. It's by the rule. Russ mentioned that they followed the rule, and we're not saying that the notice was illegal here in terms of the prospecting, but I think that as a practical matter, it makes a difference. That is to say that the local folks who would have expected to get notice of something like this don't necessarily get it with a prospecting operation. And so it's not just notice. Groundwater protections, for instance, are more robust with a mining operation, as you would expect, than a prospecting operation. And a lot of that has to do with and I see a typo, I apologize. That's baseline data is what I meant to say in this line. The groundwater protections require, for mining operations, require baseline data. And in this instance, I would argue that it's more significant. This is an area that's been explored extensively. And the risk to these groundwater systems, these are folks who rely on wells for their water, go up the more drilling you have. And so without that baseline in place, I submit that it's harder to figure out whether your water quality has been impacted. And I understand that there are abandonment procedures in place, but nothing's perfect. And even where you have abandonment procedures in place, you still have potential for groundwater contamination. And for these folks living on wells out there, obviously, zero, as close to zero risk as you can get is where they would prefer. And having that baseline up front is an important component. So those letters that we talked about from concerned residents of South T-Bar and Bar J, I think are important because it demonstrates that these are folks who did not have knowledge of this prospecting operation going forward. The first thing they found out about it for the most part was when the county has some posting requirements for that conditional use permit, but those happened in October, November, whereas the prospecting operation was submitted in July and the public comment period for the prospecting operation ran in July. And so by the time there were signs for the county use permit, there was no opportunity for them to engage effectively in the prospecting permit process. This should have been a no-brainer. This should have been based on the decision that had already been issued in 2015. That decision said that this deposit has been explored sufficiently that commercial quantities of ore exist. And so the expectation from the neighbors was that the division and the board would be consistent with that ruling made in 2015 and that a new operation to come and further drill in their neighborhood would be subject to the mining operation requirements that would have that notice and have that baseline and have those protections in place. This is a decision that this board, a different board, obviously 8 years ago, the makeup was different. But I would submit that this board ought to respect that precedent, that where the board makes a decision on an ore body, that it is beyond the level of prospecting, that it should stick to it. Those neighbors relied on that. And I think it's only right that they should benefit from having that precedent in place. And I think the board ought to respect the prior board's decision and adhere to that decision. Not doing so, I think, creates some risk. It essentially allows an applicant to come in, and if they fail to convince the board that it's prospecting, not development, it's conceivable, and as I think what we're seeing in this instance, to go back out, form a new corporation, come right back in and argue that you have a new slate. And hey, that was the other guy. The other guy thought that that there were commercial mine here. We're not sure yet, but that's going to happen every single time. And so effectively you write out this rule, this distinction between prospecting and development. If you allow a new applicant to come in every time and take advantage of the prospecting rules instead of the development rules. I think there's a significant fairness aspect there, particularly for the residents who live there and expected to be able to rely on this decision of the board. And again, I think I addressed this briefly, but Colorado law should not be defined based on Australian or other international stock exchange requirements. This board has ruled that this deposit is beyond prospecting for seeing if there are commercial quantities of ore. It's into the development stage, and I think the board should stick to that decision. This is just by way of example, this is from your board packet, and it shows the Hanson deposit as they have defined it. And so this is a fairly specific, I would argue that this is about as specific as it gets for defining an ore body. To say that the prospecting is necessary to find this ore body and find commercial quantities, I'd say is belied by graphs like this that they include in their stock presentations. This shows that they know where that ore body is, they know where the high grade is, they know where the low grade is, they know the interplay between the different deposits. This is a deposit that has been explored sufficiently so that, as the board found in 2015, that it is contains commercial quantities, and the board should find that a mining permit is required. I would like to move on to Mary Jane Sisson, who is a local resident and would like to testify to the board as to her personal experience and involvement with this project. Thank you.
Thank you all very much for allowing me the opportunity to address you. I have a very short presentation and I will try very hard to be very brief. Throughout this presentation, you're going to see pictures taken from our home. This is the view we have from the front of the house, the kitchen, the dining room, the living room. This is not the view we will have, unfortunately, if the prospecting does exist. There will be drilling rigs and so forth in the middle of some of these pictures. We purchased our home at 1377 South Tallahassee Trail in June of this year. My husband David and I did. It's South T-Bar Ranch outside of Canyon City. And we're from Louisiana. So we went back to Louisiana and began the process of closing up a farm, selling animals, packing, and all the things that one does. In October, I received a letter from Fremont County and said that the commissioners were holding a public hearing about a conditional use permit from a copy, and that owners within 500 feet were to be notified. And I was stunned, taken aback. I'm not even sure I know the words uranium and drilling, and because we had no idea any of this was possible out there. It hadn't been talked about by our Property Owners Association board. There'd been no disclosures of anything when we bought property. Yes, we did ask. And of course, we didn't know anything about the DRMS hearings because we just bought in June. So it kind of came into this. So I made plans to come back up on October 24th to address the board. Told them our concerns and that, hey, you know, we're just kind of finding out about this. Can this be postponed? But also that we as property owners, because I was not the only one, can get some information and have some understanding about what it is, you know, you're wanting to do. But they did go ahead and they went ahead and approved it. And during the meeting, there were a few modifications that were recommended. I haven't seen the final document. I had emailed Mr. Victoria. I know that they have to go back to the county, I believe, before they start drilling in 2025 and talk about what they found. They had to do some paperwork changes for a name change, and they were going to talk about the closed loop system because they don't think that was in the initial application. So prior to coming here in January, early January, I contacted the zoning office and I contacted the commissioner's office and said, hey, do y'all have it finalized? I kind of like to see what, you know, the final status is. I take some information that I already have the answer to. They said, go to the recorder's office. So I went to the recorder's office and they told me that due to the high number of complaints from the community, that whole packet had been forwarded to the county attorney for review. So then I emailed the county attorney and I said, you know, kind of trying to check on the status of this. We do have some letters we would like to share if that's applicable at this point, kind of try to get an idea of the status. I think that has been recorded now. I don't know. I haven't seen the final document. I know that there was they passed something at the last commissioners meeting, but I haven't seen the actual document to see if it was everything that was talked about. One of the pieces in the application from Okapi, and I think this has now been kind of addressed by Mr. Kazir, was the recommendation from Parks and Wildlife about avoiding construction and extraction during certain periods of the year for minimizing displacement and production areas, migratory birds, that type of thing. And I think he kind of touched on that in his presentation. And so, of course, at that time we had a question. So what does this kind of narrow the time frame down to? There was a comment in there about no surface occupancy within 500 feet of a high water mark. Water is a big concern to us. We are on a well. And so I don't really know. It's kind of hard to tell when you're trying to overlay things to see right where it is. But from what it looks to the lay people, it looks like it's awfully close to within the 500 feet of the high water mark, and it causes some concern. So when I talked to Parks and Wildlife about the recommendations that they had made, they had said that they recommend that y'all and Fremont County are responsible to monitor and enforce any recommendations that you decide to implement. And so we were wondering what of those recommendations would be implemented, but again, it does sound like he has touched on that. I did hear something from U.S. Wildlife and Fisheries, another person that's affiliated with our group. Another person affiliated with our group had talked to them, and I think that they had sent a letter. I haven't seen it, something to the effect that they hadn't been contacted yet or didn't have any information from Okapi about bald eagle nesting and that type of thing out there. Finally, this is what I see across the front of my yard. With Louisiana, you don't see elk herds and things like that. It was the most incredible sight I'd ever seen when we first moved up here. And that's not something that I'm probably going to see for a while if this happens to take place. And that saddens me. But all these slides, everything else, more importantly, it's the water. This is a residential community. There's a lot of homes out there. There's a lot of wells out there. And we really are very concerned about what this is going to do to our water. And I know that there's a lot of systems in place, but I also know life happens and things go wrong. And there's a lot of stress and a lot of concern about what's going to happen there. Anyway, thank you very much for your time.
Hello. Hi, my name is Skip Blades. Can you hear me okay?
Yes, thank you.
Great, thank you. Really appreciate the opportunity to speak with you folks today. And I'll just jump right into it. So my wife and I own 3 parcels of land near Hanson Deposit. 1 within South T-Bar and 2 within Elkview, which is a neighborhood within South T-Bar. All 3 properties are within less than 1 mile from the planned drilling activities. We're building a second home and in Elkview, and are obviously heavily invested into the area. We were drawn to the residential feel of the community, the beautiful views, the native wildlife. I mean, that picture there shows, the elk herd, which are, they visit that field on a frequent basis. That's where the middle fork of the Tallahassee is, which is a creek that rolls right into the Arkansas River. That's also right where directly where they plan to drill. So we were aware of the uranium deposit and some activity when we purchased 4 years ago. But the POA and the neighbors, there's an attitude out there, oh, it's never going to happen. But upon further research, we learned that DRMS had ruled against a prospecting permit request for Black Range Minerals in 2015 on the grounds that commercial quantities of uranium existed and any further drilling activity would require a mining permit. So when we learned Okapi, is how I'll refer to them, would be drilling, we expected a mining permit would be required and much more due diligence, some things Jeff addressed, the impacts on the aquifer, the wildlife, the land, and very importantly, the notification. I luckily had someone tell me that this permit was up for objection, and there was a 5-day window, and I caught it like 3 days before, right? It's the reason you only see one person. No one knew about it. So we were very surprised to learn DRMS had approved a prospecting permit on Hanson given the previous ruling in 2015. So as mentioned, South T-Bar is a residential gated community with over 100 parcels, most around 35, 40 acres. There is a single entrance into the community. That's that red gate looking thing. And then you can see the black line is South T-Bar Trail. That is the main road that comes in through the neighborhood. And the red line represents the Hanson deposit. The red is where they plan on drilling. Pardon me, the aqua color is where they plan on drilling. As you can see, most of the proposed drilling is very near South T-Bar Trail. Some locations are within 200 feet from the road. There are at least 18 residents within 1.5 miles of the drilling, many of them full-time. When you get outside the gate, you heard Bar J been mentioned and some of the objections you got there. That's just right outside the gate is the entrance to their neighborhood, and they have there's 30 parcels there, and they have a number of full-time residents there as well. So when I looked into Okapi, global uranium and exploration, I was rather shocked to learn that Mr. Benjamin Ballerine was involved. And upon further research, Mr. Ballerine is the Global Uranium Exploration Technical Director and a board member. He's also the largest executive shareholder with 7 million shares of stock, 2.4 million available in options in the next 2 to 3 years. Mr. Ferrier, who you'll probably hear from today, is the next largest executive. He's the managing director with 1.5 million shares of stock and 4.7 million available in options over the next 2 to 3 years and some performance-based attainment. I mean, the reality is both of them have a lot to gain by the stock price rising. So as noted on Okapi's website, has to do with Mr. Ballerine. He spent 6 years as a head of exploration for Black Range Minerals, where he gained considerable experience in identification, acquisition, and exploration of uranium assets. The fact is, Mr. Ballerine spent a total of 10 years at Black Range and was the executive director in 2015 when DRMS made the ruling that commercial quantities exist and denied the Hanson prospecting permit. So Mr. Ballerine clearly knows uranium is available in commercial quantities at the Hanson deposit. As mentioned, there's been lots of drilling and lots of data. It's shocking how much drilling has gone on. And this Okapi exhibit, you can see the Hanson deposit. It's the one, can everybody see that? Let me see if the mouse works. It's right over here where the mouse is. Picnic is down below it, where they actually did all the mining activities in the 70s and 80s. So those black dots represent all the drilling that's taken place. Hanson has been drilled over 1,000 times. I've heard upwards of 1,400 actually. And there's lots of data available according to Okapi. Quote, the Hanson and Picnic uranium deposits being significantly drilled in the past is demonstrated with a relatively tight drill spacing of 100 feet. According to Okapi, the on-the-ground team has extensive data set that would incur substantial financial investment to replicate. So clearly, lots of drilling, lots of data. So here's what they claimed in their statement of opposition. That Tallahassee, which is their, the sub of Okapi, pardon me. Tallahassee does not possess any of the raw data from Black Range Minerals test work, only summary. Tallahassee does not have access to all the same information as BRM. To the extent it does, Tallahassee does not place the same credence on that information. BRM, according to the evidence presented at the hearing, had only determined that commercial quantities of minerals were present. Tallahassee has not. But here's what they're saying to investors and the public. There's clearly a contradiction in what Okapi's saying in their opposition statement and what they're telling the investors and the public. They're telling the investors and public that more than 2,200 holes have been drilled in the district for more than 350,000 meters, which provides a, quote, rich bank of exploration data. People have been working in this area for a long time. You are trying to pick up where they left off, according to Mr. Tim Brown. Hanson and Picnic Tree are key deposits hosting 22.2 million pounds of U3O8, et cetera. Right? But there's more. Okapi claims to investors in November of 2023 at the RIU Resurgence Conference, Okapi acknowledges what I see as the truth, that Tallahassee project is in the development phase. You can see it there. They have it, that second, whatever, that uranium development Tallahassee project. And there's much more, but I think you get my point. Clearly, Okapi's telling DRMS one thing and their investors and public another. So what's reality? Reality is Okapi knows commercial quantities of uranium exist because their board member, Benjamin Ballerine, was the head of exploration at Black Range Minerals. Okapi's admitted that they have a, quote, rich bank of exploration data available to them numerous times, to investors and the public. Okapi has downplayed their knowledge of drilling history on Hanson to DRMS so they don't have to be accountable to the state Colorado requirements for a mining permit, is my opinion. My wife and I relied on DRMS ruling in 2015 that commercial quantities exist and that it would require a mining permit. We believe that DRMS should reject their prospecting permit and require them to apply for a mining permit. They should respect this board's previous ruling and respect Colorado law.
Thank you. Any questions from the board?
Any questions from the board? Hang on,
Thank you.
Process check, just timing wise.
Yeah, that's something. Let me come back to bubbles.
Do you want me to tell them?
Sure.
Okay, so just looking here at the time, as stated with the division, and we are keeping track of the time here. So the division's used about 15 minutes of an allotted 60 minutes. The appellant has used 34.36 minutes of the 60. If it sounds okay to everyone and everyone's filling up to it, maybe hear the portion of the presentation from the objectors so that everyone has had, or I'm sorry, the applicant. So everyone has had time to kind of get that portion out of the way, do a quick lunch break, and then go into rebuttals and deliberations. Does that sound fair to everyone? Okay, so we'd like to hear from the applicant in that case. Thank you.
Thank you.
Okay, good afternoon, once again. Again, my name is Joe Middleton. I am Tallahassee Resources Council. And we have a presentation we'd like to present to you today. Very quickly, though, I'd like to respond to a few of the points that were made by the appellant just now. And clarify a couple of things. First, I want to say that with respect to Tallahassee's public statements, Tallahassee has never in any public or private forum anywhere declared that they understand commercial quantities are present at the Hanson site. Secondly, I think the appellant is either misunderstood or mischaracterized the board's prior ruling, which I don't think determined that there were commercial quantities of minerals present at the Hanson site. I think the finding was that evidence elicited during that hearing was sufficient for the board to conclude that Black Range Minerals knew there were commercial quantities of minerals present there, and that was it. The board didn't say there are commercial quantities of minerals present at the Hanson site. Third, I think I just want to say that the notice requirements were complied with fully. I don't think there's any issue in terms, the division has never raised an issue of completeness or adequacy with respect to the notice requirements. I think you heard an appellant make a strong case that maybe those notice requirements could be revisited in further rulemakings, but I don't think it's fair to hold us to some standard that is not applicable today in terms of notice. I also want to say that while requirements for an NOI are clearly different than those for a mining permit, I think the rules are intended to calibrate those requirements to the anticipated impacts of each of those kinds of operations. And so I think that is why those requirements are different. And so that's what I want to say in response to the appellant's arguments for the time being. And then I'll just make a few quick points before we are we okay?
It's just too many here.
Okay,
I'm gonna
yeah.
have to just.
Dealing with some issues myself. 5 minutes ago.
Yeah, it's not what we're doing.
If we scroll through it, this particular one.
It's just not coming up on the other screen, and I just don't understand. The board screen? Yeah.
So we get there.
There it is.
Thank you, Jerry.
Thank you, Jerry.
Yeah, and now we just start from the beginning.
Somewhat
Yep.
under.
Like every time it's a different.
Yeah.
Some of it I know, some of it I would not.
Right, yes, I mean, from beginning.
Yeah.
Right here.
Yeah, you're the.
Presentation just
There
like disappear sometimes when you're presenting on Zoom.
All
right, that's it.
Thank you.
Okay, so you'll hear from me today. You will hear from Andrew Ferrier, and you will hear from Tim Brown, and also our expert witness, Ben Gunther, who are all here today. And before I turn it over to them, though, I'm going to make 4 quick points. First of all, Tallahassee has not determined that commercial quantities are present. Secondly, Tallahassee has never stated anywhere that commercial quantities are present at the Hanson site. Third, Tallahassee, its activities fit squarely within the standard definition of prospect. And finally, that approval of an NOI under circumstances like these, where a published mineral resource exists, is standard practice for the board and for the division. So delving in a little bit more on key point 1, we haven't determined that commercial quantities are present at the site. Other operators may have done that. But, a published resource this is a key point that I think is overlooked, that a published resource, a mineral resource, is not the same thing as a commercial quantity of minerals. It doesn't mean that those minerals can be extracted at a profit. So when you see a table like the appellant provided to you that lays out a quantity or quality of minerals, that doesn't mean that anyone has determined that those minerals can be taken out of the ground, processed, and sold in a marketplace at a profit, which is the essence of a commercial quantities determination. That determination depends on a number of factors, and those factors change over time. They can change certainly from the time that Cypress was active at this site in the 1970s. They changed from the time that Black Range was active at the site 10 or so years ago. And they include things like the mining method, which is a key factor in determining your costs, the processing method, the hydrology and geology of the site, as well as external factors like environmental regulation, property ownership and access, as well as market conditions. All those things change over time. It doesn't depend simply on knowing that a certain quantity and quality of minerals are present at the site. Again, it's not a static determination. And it's a determination that's not made by, with all due respect to the board or the division, it's not made by an appellant who has no expertise in these matters. It's made by a prospector who can assess the minerals in the ground, what it might take to bring them to market and to sell them at a profit. Simple as that. It certainly shouldn't be the case that one prospector is bound by another prospector's prior determination, especially when most of those factors have changed, and particularly when they don't have the same information, despite the fact that they might share a board member, that they don't have the same mining method planned, that they don't have the same processing method planned, or they don't share the same costs of production. Okay, so next key point is that Tallahassee has never stated anywhere in its public statements that we've determined that commercial quantities of minerals are present or that they can be extracted profitably. And I would urge the board members to review the exhibits that have been submitted. I think that's consistent. We're certainly not telling the board one thing or DMS one thing and public investors another. There's just a question as to understanding the correct terminology. Our statements consistently discuss a mineral resource, and we consistently say that we understand, yes, minerals are present at the Hanson site in certain quantities, in certain qualities, in certain places, but that does not equate to being able to say we can pull them out of the ground at a profit, which is the essence of the commercial quantities determination. The term development, when we use it in our public statements, and I think you saw the slide that the appellant offered with the little tracker at the bottom It's important to understand the context in which those statements are made. We don't use that statement, or Mr. Ferrier, as you'll hear, doesn't use the term development in his presentations to potential investors in Australia with specific reference to the DRMS definitions. They're not intended to imply that the company is done with prospecting. They're not intended to imply that they can move on and start developing a mine. They're intended to contrast the position that they are in with respect to the Tallahassee project with other projects that the company is undertaking. Next slide. Okay, so if you just take a look again at what it means to be prospecting under the Act and the rules, we are investigating a mineral deposit. That's right there in the definition of prospect. It's clear that when you're investigating a mineral deposit, you know the deposit's there. You don't have to be out there just wildcatting, trying to find something in the first instance. It's okay if you know that minerals are there to do additional prospecting work, see if they can be extracted profitably. That's, again, the essence of the commercial quantities determination. So what we're doing is a very traditional, straightforward prospecting program. It's a relatively small scale, it's diamond drilling, and it's the kind of prospecting that you would see on a routine basis at other deposits of this sort, or even at other mineral sites. Okay, final point before I turn it over. Final point is that we are in a situation that doesn't vary from a number of other situations across the state. These are a few examples where a mineral resource has been published. That is where companies, aside from Tallahassee, have put together tables like the one that you saw, diagrams like the one that you saw, which show here are the quantities and qualities of the minerals that we believe are present at this site. And yet we're still doing prospecting. These are just a few examples from the past few years, including the Tallahassee Resources NOI that was granted in 2022. Cripple Creek, for example, is a deposit where people have been mining for 140 years, and yet additional prospecting is routine there. And the division routinely approves additional prospecting NOIs at that property. So we're not an outlier. So those are the 4 points I want to emphasize, and then I think each one of our witnesses will go into those points in more detail. And so I think I'll turn it over now to Mr. Ferrier, and I will let him come up. Yeah, actually, I'll switch with you.
Thank you, everyone. As Joe mentioned, my name's Andrew Ferrier. I'm the managing director of a company called Global Uranium, which used to be called Carpi. Sorry for the confusion there. It's a recent company name change. I'm based in Australia. As an MD, I sit on the board and I have the fiduciary duty around all the ASX announcements that we make and essentially all the decisions that we make. On the next slide.
Okay.
So as I mentioned, Carpi or Global Uranium is an Australian stock listed exchange company. We are not affiliated with Black Range or Western Uranium in any way. There's no relationship with those companies. We have to abide by all ASX regulatory requirements, and the main one of them when you're talking about mineral projects or mining projects is the JORC code. And we think the JORC code is important here because it directly talks to that concept of commercial quantities, which is such a key definition in the DRMS definitions around development versus prospecting. So the key thing that was brought up before was my use of the word development to discuss Tallahassee. And it's done in a completely different context to the definition used by DRMS for development. When I talk about development to my shareholders, it is completely in relation to advancing a project. Development is advancing a project. Development under DRMS is more about mine development, building a mine, getting a mine permit. When I talk about development, it is in contrast to other projects we have at Okapi. Okapi has lots of uranium projects here in the US and also in Canada. As an example, we have projects in the Athabasca Basin, which is a big uranium district up in northern Saskatchewan. We have around 60,000 hectares of tenements up there. We refer to that as exploration because, as Joe mentioned, it's early stage exploration. We're looking for quantities of uranium. That is what people I speak to refer to as exploration. What Tally has here today is colloquially referred to as development because it's advancing a project, but it is fundamentally still in the prospecting stage under the definitions the DRMS provide. We do not have commercial quantities of uranium at Tallahassee to date. We need to drill to gather more data to define that. So when I talk about development in public statements, it does not in any way relate to the definition, as I've said, to the definition of development in the DRMS regulations. And I'm happy to answer any questions more on that moving forward. On the next slide, the real question then is, I guess, how do you think about commercial quantities? And that's where we think, in part, the JORC code is actually pretty helpful in terms of this, because the JORC code is very strict in when you can talk about you having a project which has commercially and economically viable. We are not at that stage. We have what is called a resource. We have an inferred and indicated resource. Inferred resources are the resources of least confidence, right? We cannot tell our investors, because we only have a resource, that this is a commercially viable operation today. We simply cannot. We do not have the data. We have not done the work. We have never actually drilled a hole at Tallahassee. Our geologist has never even looked at core at Tallahassee. We've never done a scoping study. We've never done a pre-feas. Once you've done a pre-feasibility study under the JORC code, your resources then, usually a part of those resources, then convert to something that's called a reserve. And that's the definition you can see up there today. Only once you have a reserve may you imply that you are feasibly and economically viable. We're a long way from that today. I will now pass it over to Tim Brown. He's our US country manager, huge amount of experience here in Colorado, and he'll talk to you more about the data we have and don't have today.
Thank you, Andrew. Can everybody hear me? Thank you. Yes, my name is Tim Brown. I'm a geologist with Global Uranium, now formerly Okapi Resources. Again, I'm the U.S. country manager for Global. I've worked for the company for about a year, and previous to that, never been involved with the Tallahassee Uranium District. So this is new to me, but I'm working in the uranium business here. I'd like to make a few points today about why our current data is insufficient. And we do not, and make the point that we don't have the necessary data to evaluate potential mining and processing methods. We just don't know what would be the best technique to go to mine underground, to do borehole mining, to do anything like that. We don't know those answers yet. That's part of the work that still remains. And previous feasibility studies prepared by Cypress don't meet those current applicable standards. They were designed for an open pit mine, and that's not going to happen today in the Tallahassee district. The data that we have available from Black Range Minerals is incomplete and is not sufficient for us to determine commercial quantities at this time. In addition to that, we lack access to historic core samples that were collected by previous prospectors. We know there are core holes drilled out there. They belong to a different company today. We don't have access to them. We can't go look at them. What we're trying to do with the program we have now, the drilling and the testing program that we're proposing, is to collect a variety of data to advance us to a scoping study level. And we'll talk about the scoping study here in a minute.
But really, as you can see on the screen, we want to collect detailed geologic data, hydrological data, metallurgical data, geochemical data, geotechnical data, and environmental data to help us complete our scoping study, which we hope to do later this year. Next one, please. Yeah, and just to show where we are today with respect to the process, on the left-hand side of the screen, you can see an arrow pointing to our position today, where we are pre-scoping study. Each of the studies, as you go across the top of the screen there, require higher quality and higher amounts of data to give you those higher levels of confidence. Again, we need to collect the data today so we can advance to the scoping study. The next study after that is a pre-feasibility study. I won't read all the definitions under there, but again, it takes more data and better data to complete those studies. And it's only after the pre-feasibility study that we can determine commercial quantities and publish and announce commercial quantities. That's when you can announce oil reserves, which we equate to commercial quantities. We have a long way to go before we get there. And then even beyond that is a feasibility study. So we have a long path ahead of us before we can get to the commercial quantities. Next, please. I'd like to draw some comparisons between where we are today and what Black Range was doing in 2015 and help clarify that distinction here. What Black Range was doing was they wanted to do a pilot test of borehole mining. We're proposing standard exploration drilling. Black Range said they had completed a scoping study. We haven't completed a scoping study at all. There was an apparent determination of commercial quantities by Black Range Minerals. We have no commercial quantities determined here at all. Sample size, and one of the reasons why Black Range had to be considered for a mine permit was they were going to pull a sample out that was nearly 200 tons in weight. The extraction core that we're going to pull out of the ground, and you saw pictures from Mr. Kazir on what a box of core looks like, is much, much smaller. Total volume might be around 4 tons. The size of the hole that Black Range wanted to drill was 12 inches in diameter. So a much bigger hole. We're proposing core holes at this point at 3.5 inches in diameter. And as part of that borehole mining test, they would excavate a room underground, probably larger than the room we're in now, 36 feet in diameter, and pull that sample out of the ground for additional testing. We're not doing anything like that. As part of Black Range Minerals' work, they would build big mud pits near the creeks. We have a plan that we won't even use mud pits, and we'll use this solids removal unit. And I'd like to talk about that for just a second as well. The pictures on the left show this trailer mounted unit, which is a relatively new development in the exploration business. These are being used more and more. I've got colleagues in the industry using these more and more because it's so much more efficient and easier to use and to contain drill fluids on site. This unit separates drill cuttings from the drill water that are coming up out of the hole. This will minimize the impact on the environment because we don't need to dig and use sumps, which are big mud pits next to the drill. It will protect wildlife. They're not going to wander and fall into your sump. It also protects the water and it protects the soil. In addition to that, it decreases the water consumption at the rig. It reduces the quantities of drill fluids required, and it reduces wear and tear on the equipment. As importantly, it improves the health and safety of the workers around the drill, and it also improves the efficiency of the drilling operations. The next slide shows one of these, a flow chart of what might happen here. The picture on the upper left shows the core in the core box. 2/3 of the material in that drill hole goes off to the lab, to the geologist for evaluation. But you can see the drill rig sitting above a hole. The drill steel in the ground is in blue color there. The drill bits down at the bottom in the gray color. And then the drill fluids, which are pumped down the center of the pipe, wash back up the side of the hole after they lubricate the bit to keep it to keep it cool as the hole advances. But the critical thing here is the path of the green arrows at the top of the hole. The fluids are contained as they circulate. They get pumped over to the solids removal unit where they go through a centrifuge. The centrifuge separates the water from the drill cuttings. The water, which is clean at that point, is recirculated back down the hole, shown by the blue arrows. The cuttings are all contained in a leak-proof container where we can cover it, where we can sample it if we need to, and then we can take that off-site. There are two facilities in Colorado that will accept those cuttings. One is Clean Harbors Deer Trail facility, and the other is Republic Services Foothills facility. So we've done this to solve many problems for us and to keep things much more environmental friendly and to contain any of the cuttings that are on site. Thank you very much.
And Tim, before we move on to Mr. Gunther, I would like to just follow up on a couple of points that the appellant made, because I think you're the right person to address them. We heard a lot about Mr. Valerie because he's a director on Global Uranium, and he was a director previously on Black Range Minerals. What is your understanding of Black Range Minerals ownership right now?
Black Range owns a minority interest in the project today.
And who owns Black Range Minerals itself?
Yeah, Black Range assets were purchased in 2015 by a company called Western Uranium, which is why we don't have access to the core now. We did receive some data when we launched the project, but what we have is insufficient and incomplete. We know we don't have all of it. That's why.
And so Western owns the data that Black Range owns.
Yes.
Okay. I think that's it. Thank you.
Thank you.
Hello, my name is Ben Gunther. I've been retained by Tallahassee Resources to provide expert opinion on the issues being discussed today. I have a bachelor's in mining from Colorado School of Mines in 1974. I have over 40 years experience in mining engineering, mining studies, mining projects, mine management, execution. I've been an executive. I'm currently doing consulting, and I'm currently a board director of a junior mining company. I've been accountable for reviewing and approving mineral resources and orders of reporting for several decades. The first, and I've given 4 opinions that I've provided in a report and we'll discuss here. The first opinion is that commercial quantities is equivalent to ore reserves. And ore reserves are defined as the economically viable and technically mineable part of a measured and indicated resource. So you've got a mineral resource, and a portion of that resource can be converted to a reserve after you've done the appropriate studies. An ore reserve is the mineralized materials planned to be mined and processed as defined in a pre-feasibility or a feasibility study. The term commercial quantities is not used in current international reporting standards that are used in Australia. They're used in the United States, that are used in Canada, and really now practically all jurisdictions of the world. The only jurisdiction I know that doesn't use them right now is China. Okay. But based on my experience and general understanding of the term, commercial quantities is equivalent to ore reserves. It's the material that can be mined and delivered to a processing plant and produce a commercial profit. The second point is mineral resources are not commercial quantities. A mineral resource is a realistic inventory of the mineralization that has reasonable prospects for eventual economic extraction in whole or in part. It hasn't determined that they are economically extractable. It says that they have the reasonable prospect for eventual economic extraction in whole or in part. The third opinion that I proposed was Tallahassee's activities proposed under the NLY are not development activities. Development activities are defined by the DRMS as activities that take place after economic quantities are proven. The data generated in Tallahassee's activities, Tallahassee has not published an ore reserve. Tallahassee has not published a pre-feasibility study or a feasibility study that would be necessary to determine commercial quantities. And my fourth is that Tallahassee activities proposed under the NOI are typical activities, and the data gathered are precisely the kind of data needed to advance studies necessary to make a commercial quantities or an ore reserve determination. Thank you.
Thank you, Ben. So just to clarify, mineral resources versus commercial quantities, the mineral resources are resources that could eventually become profitable, extractable in the future.
In whole or in part.
Yeah, but are not now.
That they haven't been proven to be economically extractable now. Okay.
Yeah, I think that's our presentation.
Thank you.
Any questions?
Did you have a question, Joe?
Just for clarification, you folks, Mr. Brown mentioned the use of a scoping study. Isn't that also known as a preliminary economic assessment?
It's not a scoping study, and I can ask Mr. Brown to come and address this more thoroughly, but a scoping study is just a study that helps you define where you're going to go, what questions you need to answer with respect to the project. You know, what are the data that I need to gather? What might be a good mining method to investigate further? What might be a good processing method to investigate further? No one that we are aware of has prepared an actual scoping study. I know there are references that Black Range made to a scoping study in the past. We certainly don't have access to that. We would like to prepare a scoping study. I think if you look at our public statements, consistently what they say is that we are trying to put together enough data to put together a scoping study, which would allow us to kind of zero. It's a continuous process. And that's just another sort of link in the chain that allows you to dial down with more specificity and to look at things more carefully. And so at that stage, you might say, well, there are 3 potential options for mining method. What might be the cost for those? What other data might we need to evaluate those? Or there are certain, you know, do we need to, and this is all hypothetical, I'm not speaking in reference to Tallahassee, but it might be something like, can we process minerals on site? Do we need to build a mill? Do we need to truck those minerals to another mill somewhere else? Those are the kinds of considerations that you might start thinking about at that scoping study, you know, phase. But certainly we haven't prepared one. And certainly another key distinction is that even if we had, that is not a determination that commercial quantities are in the ground. That happens, as Mr. Gunther explained, really only at the pre-feasibility phase of the process at the very early. Sometimes it takes until you have a feasibility study in order to get there. You know, to have what it, to be able to, you know, bank on the estimates in question, to be able to, you know, gain investment and financing, to ask a bank, for example, to finance a mining project, you would typically need something like a pre-feasibility study that show at least, and oftentimes a full-blown feasibility study that assesses all these components we're talking about. Whether it's, you know, certainly the minerals in place, certainly their location and the quantity that you think are there, and the quality that you think are there, but also all those other factors that play into whether or not profitability can be achieved, which includes, you know, is the mineral resource actually in a place where I can get to it? Are there significant pockets of it that couldn't technically be mined, even though we know it's there. Because the technology just doesn't exist. You know, is it the case that the minerals have some aspect to them that would require certain processing? And that processing might be extremely expensive or cheap for that matter. And what's the market price right now? And do we think that's gonna stay the same? Or is it gonna change from is it gonna be different than it was in 2015 or 1987 or 1970? Certainly all that plays into it. So that's why, that determination, it has to be left to the prospector, and it has to be left to the prospector at the time that they're looking at it. They have, our folks have a fiduciary obligation to their shareholders, to the other members of their companies, to, assess things and provide the due diligence on a personal basis. They can't rely on the data that somebody else put together 10, 15 years ago. They can't with a straight face go to the bank and say, well, we've got, Cypress Minerals work from 1979. I think that's good enough. Don't you? No, they certainly wouldn't buy it. And they certainly couldn't go to the division and say, we'd like to apply for a mining permit for this activity. And we don't have any water quality data, but we do have data from Cypress from 1979, or we have Black Range Minerals data from 2015. That just wouldn't fly. We don't even have the necessary information to put together a mining permit application. So,
thank you. On that note, I just want to try to connect all the dots here. So Black Range is acquired by
Western Uranium.
Western Uranium.
Yeah.
Tallahassee is a division. What do you call Tallahassee under the?
No, Tallahassee has no affiliation at all with Black Range. It's
of Okapi.
Okapi, it's
Okapi.
a subsidiary. I
A
think,
subsidiary of.
Yeah.
And so then through like a purchase of the subsidiaries, is that how you ended up with the Hanson and the Picnic deposits?
That's a question probably better answered by Mr. Ferrier.
Yeah, so if you don't, do I have to be able to speak?
It doesn't matter.
Oh,
It's
okay.
fine. It's like just.
Yeah, so our interest in the Tallahassee tissues was through two separate transactions. So initially we did a lease agreement with the Taylor and Boyer families, which is north of the Hanson deposit where we're talking now. Our interest in Hanson, which this NOI relates to, was through a transaction with a company called STB Minerals, and they were the mineral right owners of that Hanson district.
And are they still the mineral right owners?
No,
You bought that mineral
yeah, we
rights.
acquired an option.
Okay,
over
so
those
you
mineral rights.
acquired those mineral rights from them.
Yeah, and my understanding, STD owners is a group of local homeowners in that same division who own the metals.
Homeowners in that division own that.
Right.
Did they own it when it was with BlackRock?
I don't know how long.
Black Range, sorry, I've got all my.
Yeah, we have an agreement with those homeowners, yeah. And I don't know when they acquired their interests, right?
Any other questions at the moment? What kind of, we've heard presentations from, the division, the appellant, the, applicant. You guys, I believe, just so you know, from a time check, used 28 minutes of your 60, correct? Okay. So it's 12:17, 12:15 for that. I believe that we would maybe like to take a break for lunch. Half an hour sounds sufficient, less than a half an hour? Who is feeling? 22 minutes? 25 minutes. Does it work, Cammy, to try to shoot to restart at 12:45? Back there. 12:45, have everyone start back up?
Does that give everybody enough time?
Huh?
Does that give them?
I know, that's my
Yes.
question.
Yeah.
Personally, I'm gonna say 12:45 start. I wish you all luck finding lunch that quickly. Some of us have some long drives back to places outside of Denver, and it might be getting longer as the time progresses. So we're gonna motivate to do a brief lunch. So 12:45 back in here. Thank you. Be like, yeah. Thank you. Everyone, Karen, you can hear us on Zoom? Thumbs up's fine.
Yes.
Okay, great. Okay, so we'll have rebuttal from the division and, oh, sorry,
Your camera's off.
our camera's off. Oh, thank you. Oh. How about now? Better? All right, thank you. So we have about 45 minutes, the division for their rebuttal. Appellant has 26 left for rebuttal and 32 for the, well, actually, is that the applicant, since we, so, yeah, okay. Objection. Appellant, has 26 left. The applicant has 32 minutes left, so, we'll hear some rebuttal here from the division. Thank you.
Madam Chair, you ready for the division's rebuttal?
Yes.
Okay.
I'm Tim Kazera, again, representing the division. One of the points that was brought up is the 2015 board order that the project at the time was mining and not prospecting. So bring part of that up is that was the borehole mining project, and I'm going to show you kind of compare and contrast those two situations. So this particular NOI is for core drilling. It's a common prospecting and exploration procedure. Yields mostly an intact cylindrical rock core for the entire depth of the hole, and it allows the core allows analysis of geology, fractures, rock strength, assay of the mineral content, lots of geotechnical properties that we need for mine development and other things. Whereas the borehole mining is a high pressure water jet that creates a slurry of the material that they're pulling out to be extracted. And none of these above detailed analysis are possible with the slurry. And it's generally used for a mining or even a bulk sample collection, which is what we were looking at back in 2015 is this is a method of bulk sample collection. So that was the crossover where the division came down, thought it was prospecting because we can't dictate how you collect your sample. Just the board came down with the borehole mining is more of a pilot project, and that falls more under development. So that was the hair splitting, I guess, if you will, for what happened in 2015 with the Hanson NOI. Got an additional slide that just kind of shows the difference on the, I think it's still everybody's left, is a typical core drilling operation. So just a straight hole and small diameter versus on the right side is what borehole mining looks like. You lower a high pressure jet in and it just literally sprays around it. It reduces that ore body to a slurry so you can suck it up in a vacuum. So there's no intact rock or anything to look at. It's just what if you get a bulk sample and how do you process it from there?
You know, I think it's important to note, just Scott Schultz for the division, that the application that was before the division was fundamentally different than the one that the Black Range order addressed. And this is why, because these are fundamentally different processes. You know, I think the applicant used the terms traditional and straightforward core drilling. And we would agree, this is about as division believes that this prospecting application involving, again, 20 core drilling samples, roughly up to 700 feet, is a traditional prospecting activity. Fundamentally different than what was before the board back in 2015. Talking a little bit about kind of the groundwater protections. I'm going to try to talk in non-expert terms, and the experts will jump in to correct me in any way, but this core drilling, approximately, again, up to 700 feet, is the same as what a water well would be drilling for. These are, DWR has the same, it has the same requirements as what the borehole abandonment requirements would be for this core drilling. Arguably, this, given that the applicant has proposed to use this solids removal unit, this core drilling would be even more protective of the environment than a typical water well. So again, not to, I guess, sweep aside any of the objectors' concerns about the hydrologic balance, or any of their concerns about, obviously, to their wells. But the division feels very strongly that the application before it is protective of the hydrologic balance, again, given the SRU that is in play, and given the borehole abandonment requirements that will be adhered to as well, using the bentonite, the special protections taken care of at the mineralized zones. So the division doesn't believe that there will be any impact to the hydrologic balance with, again, the application for drills. One further point on that is the objector talked about that there's no baseline data. How do we know whether this core drilling would impact the baseline data? Well, in order to determine it, to have some baseline data, you would need to drill for some groundwater monitoring wells. And again, I don't think that this core drilling would be really that much different or any different than what would be used for a groundwater monitoring well. Again, not to dismiss the objector's concerns about the hydrologic balance, but I think with the application in front of it, the division feels that it is protective of the hydrologic balance. I think my last point before we open up to questions and any other points is the legal definitions, right? We have the definition of prospecting at play. We have the definition of development at play. We have the definition of mining operation that the objectors brought. Tim went through it a little bit in his presentation, but the division didn't view this application with this blinders on. Again, it is an application for a notice of intent to conduct prospecting, but that doesn't mean the division didn't dig down and consider whether it is more appropriate as a mining operation. But I think given the totality of the circumstances, all the definitions at play, including, and I think it kind of gets a little bit lost, is the, in the definition of development is that also the term that the minerals are in existence in commercial quantities. And I think the applicant really hit home on that issue. They are stating that they do not know whether the minerals are in existence in, quote unquote, commercial quantities. I don't think it's the division's duty to second guess an applicant in that. But at the same time, the division, again, doesn't look at these applications with its blinders on to make its own determination whether it would possibly fit better under a mining operation. So I think that's important to note, that all of the definitions are looked at by the division. All totality of circumstances are at play, and I think that specific definition, minerals are in existence in commercial quantities, is important. That is something that the division did take into account. And then lastly, that might be lastly. I'll ask if the board has any questions. Or I will, one final point is, and I think Russ will clarify this and say it much more clearly. But I think if we go with the objector's interpretation of why this is a quote unquote mining operation, I think that really essentially eliminates the definition of prospecting. Again, we see this as a very traditional prospecting application. And if the division or the board were to second guess that this is better a mining operation, again, it technically may fit the definition of mining operation. Well, that essentially eliminates the term of prospecting. And there's all sorts of practical and business reasons why entities should have the ability to, again, determine whether minerals are in existence in commercial quantities. So I think that kind of overarching public policy, how do all these definitions fit together, is important for the board to take into consideration here. I know the division has thought long and hard about that and did consider that as well.
Madam Chair, and so Scott stole a little bit of my comments and stuff here, but I'll be brief. Staff has done a great job in discussing the review process for this particular prospecting application. My comments are a little bit more global in perspective, if you will. There should be some concern about the impacts of moving forward if somehow this is determined to be anything other than a core drilling prospect. And there are potential ramifications staff wishes for the board to consider. The division reviews and approves several of these projects a year. These reviews are based on our act and our rules and almost 50 years of similar projects coming before the board and its division. Your staff has approved this NOI based on our collective 50 years of professional judgment as well. So staff is very cognizant of the difference between in definitions and the difference between prospecting and development. With that said, this project fits the definition of prospecting as it's an investigation of the deposit. It's not development. If it's determined that based on the other drilling, if a determination is done otherwise, based on other drilling having occurred, statements on the internet, or other non-jurisdictional issues, this is something that has a potential to exist for future drilling projects that could end up with every single one of those being in front of you on appeal. Information, for one thing and stuff, this is based on the fact that mineral belts in Colorado have been drilled and drilled again. There are tens of thousands of NOI drill holes and stuff across the state. And so to limit that by saying it's already been drilled out and you should have enough information is not correct, because the information is confidential, it's proprietary, it can be corrupt or even lost. So it's not the division's responsibility or its jurisdiction to determine what is enough information, nor police internet statements. Those are all business decisions and stuff that are outside of our purview. It's the division's task to ensure prospecting projects submitted meet the act and the rules and will be reclaimed correctly. This prospecting application has done that. And with that, I'll close.
Did you have something to say?
Madam Chair, thanks. Mr. Schultz, Mr. Kazier, and maybe Mr. Means. Maybe I misunderstood the objectors when they brought up the 2015 decision by the board, but that wasn't just a straight up NOI for prospecting, because that was already going on. If I understand this correctly, or correct me if I'm wrong, that was to approve an application for a third modification to NOI to conduct prospecting, correct?
This is Tim Kazier. Yes, that's correct. I was the specialist that oversaw that, and it was their third modification. And we'd had several discussions before they even submitted whether they could collect the sample in this particular method. And we agreed that, like I said, during my rebuttal, that we didn't dictate how you collect the sample. And so that's what it got hung up on, is that the method was more akin to a pilot project than it was to a particular way of collecting the sample.
But had Black Range already been conducting prospecting operations.
Correct, since about 2009. So they've been doing
They had-
about.
And so this was a
60.
modification and then brings in the borehole mining, which then introduces something that looks, smells a little bit more like mining than just prospecting, given their previous activities.
That's correct.
And then help me understand, Mr. Means, I think you kind of you mentioned it or you brought it up there. Mining company A goes in and does some test sites, does some prospecting, sells it. Is any of the results from the prospecting held by the division that other companies might come in and then utilize or view?
Yeah, no, we do not keep that information. That's all proprietary and that's so they keep their results. We do not see that. That's also on the federal level too, federal projects and stuff, unless it's like the DOE lease track program and stuff where those have to be shared and stuff with the Department of Energy. But on BLM, they can go out and do prospecting and they don't necessarily have to share that information with BLM. It would be, in a perfect world, it'd be great if there was a database where all that information was available, but it is not.
Yeah, so that you have possibly 2,000 boreholes already tapped into this site. Nobody necessarily has that information.
The
available.
company, yeah, the different companies would have them, and I know in some instances I've heard and stuff like if somebody wants to buy those assets, they would have to maybe pay more for that additional data and stuff and that, and some companies and stuff would rather confirm their own findings rather than pay for something and stuff they're not confident on.
Then, Mr. Kazir, last question here. You had it on your original slide presentation when you opened this up. It was the timeline, basically. I think we were talking roughly 5 days to tap and reclaim, essentially. And so that's what we're looking at, and everything's there off the site. It's done.
Off that particular drill hole site, yeah, and then they move on.
To the next drill hole
Next
site.
one, yeah.
So if we're talking, remind me, how many drill hole sites are we talking?
20.
20. So if you spread it out, you're doing just one at a time. That's what, 100 days?
Roughly, yeah.
Roughly. And then they're done. But help me understand the modifications that might come and sort of keep equipment and other operations on the property and moving forward. What's that universe look like?
So if they did come in with a modification, it's the same process as this one. It's the same application. It's just the only thing that doesn't change is we'll keep the same identification number for the NOI. Everything else it goes through the same 5-day public comment period, the same review process. We treat it just like a new NOI application. So nothing's different with that than it would be with what we did with this one.
Do they have to though wrap up their operations? So they have to complete this type of activity, or could they come in and ask for modification while you already have equipment on the ground doing prospecting?
They could do it either way. There's no defined process. I guess.
Can I ask how long prospecting operations typically might occur?
Well, we haven't, just what, 2021, 2020, we have new rules. The prospecting operations are 5 years. After that, you either need to start reclamation or come in with a modification. So we've got because in the past, we've had prospecting operations that lasted way too long without any activity. So the new rules have limited this to 5 years.
And then, I'm sorry, help me understand that this is the last one, Madam Chair, I'm sorry. The trails. When I think about trails, I'm thinking like you're hiking or you're taking a donkey and carrying, this is kind of Clear Creek County type of old mining days type of trails, or is this like a road of some degree to transport vehicles and equipment along?
I would liken it to more of a two-track trail as opposed to single track, dual track, where there might be evidence of semi-regular traffic. And I've kind of overlaid it over Google Earth and looked at it. And some of these tracks are actually graded roads. Some of them are, you can kind of see where there was maybe farm road access or something, or it could have been maybe trails left over from the activities back in the 70s, who knows? But I would liken the trails to more two-track rather than single track.
Is there a definition or is there a difference between trails during prospecting versus roads for development or?
No, the only reason I bring up trails is because the applicant specifically in our application, it says roads, new roads and existing roads, and they specifically crossed out roads and replaced it with trails. So I'm just making that distinction that they're planning on using the existing trails to the maximum practical extent. And not creating new roads, which is more, I guess, more disturbance, if you will.
Mr. Mock, if I could tag on that a little bit, for a mining operation, when we look at roads and that, two-track roads and stuff that are in a mining operation that are significantly upgraded for the purposes of moving equipment and part of the mining operation themselves and stuff, those are all part of the permit, for a mining permit. But under a prospect and stuff, there's two-track roads and things and stuff that are, if our general rule is if you drop a blade on it, you have to reclaim it. So when trying to minimize impact, they'll use the existing roads that are there, existing two tracks and stuff. But if they have to, say, go through a gully or something like that and widen that out to get the drill through, they're required and stuff to reclaim those. And which for a mining operation, it's more of a defined permanent structure and stuff as opposed to a temporary disturbance.
I jump to someone else, just because it's kind of on theme to what Mr. Mock was alluding to. And I hear what you're saying, Mr. Schultz, about like if we were to eliminate and say kind of, hey, any kind of activity that looks more than this equals development, then sort of what's the purpose of, prospecting. We've looked at some sites where, hey, they're gonna come in, put a drill pad down, do 4 holes, in and out, 10 days, had the discussion, approved it. This one, so just tell me if I'm thinking about this properly, because this looks like an open meadow. You have 5 years if you approve a notice of intent to then say, hey, yes, this is yes or no activity, right? Essentially to do it, but
no, I think that's a misunderstanding there. Yeah.
Well, he said, so let me just finish my question.
Oh, sorry.
So I think what you were saying is if we were to approve this notice of intent, the operator has 5 years to say, hey, we've got this information, we are going to move forward. But what does the actual activity on the land look like? I mean, are we talking 22 weeks? Are we talking the summer in and out? If this was approved because they have it and they have all this time, can they leave a drilling rig because they got halfway through over the winter and go on to next summer? What does that look like?
Yeah, you bring up a point because this is an area that's not really conducive to winter operations. And
Sure.
so that's what I try in the past, the operations here, and I think as this one goes, would be limited to, we'll call it the drilling season, where the prospect for weather problems are going to be minimal, and I would expect to be buttoned up. I can't remember the time frame of the CPWs. But I think generally, I've done inspections up there. I think you're usually probably pretty good until sometime in maybe late October. Even I've been up there in November and it's okay, but that's dependent. So I would, and maybe this is a better question for them as applicant is specific of what their time frame is. But the idea is you don't want to be stuck up there with a drill stuck in the ground for over the winter. The expenses there are just impractical to leaving it there. So
right,
you want to get it buttoned up in a short period of time, which is more of the summer drilling.
And I agree with you, and you would assume that an operator would also want to do that and wouldn't want to have a bunch of equipment sitting on the land, because that's just not very economically intelligent. But I think that maybe the crux of this conversation is that it's taking a definition of prospecting that could be, say, 2 drill holes or something that looks fairly large in scope, and putting it through a process that doesn't really have a lot of those nuts and bolts lined out, like a mine permit might have, that says, hey, we're going to come in here, it's going to look like that, there's going to be a fence, there's going to be a big sign, there's going to be this, there's going to be that. is there anything aside from assuming that reasonable business conduct would happen and someone would be in and out in a drilling season?
I guess the other thing,
Outline.
you know, we would typically, we inspect prospecting on an annual basis, especially if there's things going on. If there's nothing going on, there's no reason to inspect it, right? But if there are operations going on, it's our guidelines internally are to inspect it annually. So we would be
I'm
checking up
gonna
that.
ask it a different way.
Okay.
From a view shed perspective, I'm looking at an operation. What does this look like within the duration of drilling? What does it look like in the off season of drilling? Can someone leave their drill pad out there? What are the checks and balances in place for what an operation looks like that doesn't maybe appear to be more than prospecting?
As far as checks and balances, we would get the abandonment reports to say what's been done, and that includes reclamation done on the site. As far as, let's say, worst case scenario, they started drilling in late October and storm came in, they maybe get a rod hung up, they can't get it out, whatnot. I don't know that we have, other than just, you know, checking in and having a working relationship with them, I would expect them to let us know. We don't have requirements there, but I don't.
I have a question is, say, if they get into this program with their 20 holes and something happens, you know, the rig breaks down or whatever, and they get 10 holes done, can they go into the next season? And
Yeah, this
finish
is
their program?
because so the application form gives a duration for the prospecting operation because we're limited to 5 years. Usually they just put in the 5-year period just to make sure they're covered if, you know, for weather and whatnot.
And they're required to do whatever they get done. They do their abandonment reports within that time frame.
Correct. So
And then-
as soon as you drill a hole and pull out and you get it abandoned, that report is required to be submitted within 12 months. And I gotten on previous prospectors for, you know, we're coming up on 12 months. Where's the report? So that's we follow up on that pretty diligently.
Madam Chair, if I might, to add on to Tim, so that, we have annual reports that are required for prospects and stuff now, which we never did. And that, those came into effect and stuff, I don't know, 6-7 years ago. We have annual reports, we have the drill program, the drill abandonment reports. The other thing and stuff I want to clarify is that 5-year time frame is the time to complete your prospects and have reclamation done. So there's got to be time and stuff for vegetation, other things and stuff there. That's not a, and they went in the plans that they submit, they give us timeframes and stuff. You know, we have the chart up there. They're figuring, you know, 5.5 days per hole or whatever. Things happen, and that's true and stuff. So it could bleed, this project could bleed into the next year. That is correct. But with 20 holes, we've had projects and stuff that over 100 holes and stuff that have gotten done in one season. So it just depends. Each project is independent, but on this one and stuff and that in particular, they have a time frame, they have a plan. So we would be looking at their annual reports and stuff and that. And if there was something irregular and stuff and that, we would be flagging that and having discussions and stuff on whether they're following their plans or not. Leaving equipment on site, they're not approved to do that. So that could be a violation and stuff. If they did it and that without a proper cause and stuff, that would be something we could bring to the board and stuff for discussion.
And the bond release is held until the program's done.
Correct. Yeah, we don't do partial releases and stuff on NOIs and stuff because for one thing and stuff, the amount of money that we get for an NOI application doesn't even cover the time and stuff and that to really review the application. So we want to make sure and stuff that, you know, we're conducting 3 or 4 inspections on these sites and stuff and that we're not going to release the bond until it's complete 100%.
Thank you.
One thing I will add, and this could be a question for the applicant as well, but in their application, as I read it, has a sentence in there that says, we plan to conduct our drilling operations during a 60-day window between May and December, as this was recommended by CDOW to avoid impacting the resident big game animals. So I read that as a commitment to conduct the drilling within 60 days. Yeah, that's a question I think the board can ask the applicant, but that's how I read this application.
So I think that does put some guardrails on when and how long this could be dragged out, when it would be conducted. To me, it seems like they're committing to 60 days.
Madam Chair, if I could follow up on that one, it's also related to your question. When we think about what the guidelines CPW advises on, so they've got to conduct it within a certain time frame to avoid winter range, calving season, whatever that might be in these cases, but that means the activity people on the ground doing things, or can you leave the equipment there through that season? I mean, or does the ground have to be cleared to avoid activity during certain time specified by Parks and Wildlife?
Mr. Monk, let me just make sure I understand your question. So like leaving the SRU unit out there.
Can you do that?
Throughout.
Can you do that if you go beyond or fall within those boundaries that Parks and Wildlife wants you to avoid? What's the activity? It's kind of like road construction, right? CDOT, in most cases, I think if it's an active road construction site, you might have cones and everything out there. It says speed limits reduced to, but unless it's an active site, that all doesn't quite apply. So you get what I'm saying there?
If I can, it's just based on historical reference, if you will. And that usually it's something we talk to CPW about activities and stuff. They're talking about actual activity, trucks moving in and out, drill rigs running, and so forth and so on. If equipment's parked to the side, it's not any different than farm equipment and stuff. It's just parked there and stuff out of the way. And that, so there's no activity. They're not moving things around or doing anything along that. Activities and stuff like around a sage grouse lek or something like that. There's certain noise requirements and stuff that are there. Those are all related to the actual mining activity, prospecting activity. They're not related to equipment that are parked.
That's what I suspect.
One follow-up, maybe not directly on point, but I think it does illustrate the applicant's desire to minimize disturbance, is that it talks about describe and locate any structures to be constructed. The application says portable sanitation closets will be available for crews, will be centrally located and will be removed at the end of the drilling season. So it doesn't necessarily go to the point of like an SRU. Again, I don't want to get into the business sense of leaving an expensive piece of equipment out there over winter, but the fact that they are, again, removing porta potties, I think goes to the heart of minimizing the surface disturbance.
Really briefly, you gave an overview of borehole versus core hole. I just want to confirm, though, that when you say the method of prospecting that's here on their application, it does say borehole, but it's not the kind of borehole that we were seeing. Nothing there?
Yeah, that's an important point. Yes, I think sometimes borehole is interchanged with borehole is basically the hole that you drill, whether it's core or not.
Sure.
Borehole versus borehole mining is you kind of have to add mining on the end of that term to get the slurry thing. So yeah, I can see how it could be potentially confusing. Sure.
But when you say borehole, it's really the picture on the left of the slide.
Correct. Yes,
Small
that's
bore,
their
3.5.
yes.
And I think again, going back to the application, I think the difference is the borehole mining was roughly 12 inches in diameter. In this application is 5 inches in diameter. And one final thing on, again, the openness of the application is that, again, they committed to the reclamation. They're going to salvage topsoil, but then they also state that final seeding will be done in the fall. So if you have equipment on the pad, you can't do the final seeding in the fall. And I think this application, they've committed to the final seeding in the fall.
Of year one.
That does not
Well, going back to Tim's question is like, if it's 100 days, we're in a 60-day window with roughly, let's call it 6 days per site. So you're only gonna get 10 holes done in one season if you're really efficient, right? So we're looking at, just from simple math, we're looking at 2 seasons. So those, ideally, if you get 10 holes done in the first year, those 10 pads will be reclaimed and seeded in the fall.
Okay, I don't see any more questions from the board. At this
I
time.
have a question.
Of course.
My question is about water quality, because that's, I think, the biggest concern of the neighbors. And the core drilling clearly is a lot more protective than bore. But what is the process if there's just a once-a-year inspection? What if there was some contamination of water? How might that be dealt with?
I guess my first question is, how would you know that there's any contamination? So and we'd have to have a complaint to investigate. The method of the system is about as clean as you can get. Yeah, sure, things can happen. And I guess that should be reported in the annual report if there are any significant problems.
I think if there's obviously any allegation of contamination, that would be done through the typical complaint process. That the division routinely responds, and it is a pretty quick response by the division. So that would require, I think, potentially, it's, again, we're really getting into the hypothetical, but would potentially require further investigation
and inspection.
Obviously, an inspection.
The Russ made with the division and stuff, if there was an indication of some kind of contamination in that it would obviously have to come through a complaint process and stuff there. From that point in that, we would be looking at it, and it's also something that's enforceable in front of the board. And that one of the primary primary objectives, if you will, and stuff is to minimize impacts to the hydrological balance. And that doesn't matter whether it's an NOI or whether it's a mining permit. So if a prospector and stuff and that were to somehow and stuff cause the issues and stuff like that, that is an enforceable issue and stuff in front of the board, which could require, significant studies and addressing that issue and stuff. So it's not like Brent would ignore it or anything like that. We get on it, and that typically those kind of complaints and stuff and that internally we have a standard and stuff that if it has an environmental impact, we try to get out there within 5 days or less. Just depends on weather and timing and that and stuff. So if we were to get a report, we would act on that quickly, and then it would be in front of the board just as quickly as possible.
So it wouldn't really be any different from if it was mining versus prospecting. The response would be the same.
Precisely.
That is correct. Yes.
And in context, has there been, to the department's knowledge of all the drilling that's been done historically since '79, has there been any complaints about contamination from previous activities
Let me start with,
that you know?
I will say that the NOI program probably didn't get as much attention in the first 20 years of our program that it certainly didn't get as much attention then as it has in the last maybe 10 or 15 years. To my knowledge, I know of one construction site where we got a complaint that actually installing monitoring wells interfered with down gradient monitoring well. We investigated that. That's the only complaint I'm aware of where a prospecting operation had any complaints from water quality, or that was more of a water quantity as opposed to water quality.
And was that in this deposit build?
No, this is a different area.
Okay, thank you.
Yeah. And my 23 years, I can think of, that's about the only one I can think of and stuff like that we have any kind of knowledge of stuff. That's not to say it.
Anything else for the division right now? Okay. Thank you, gentlemen. Okay, so we're here now from the applicant. You have about 32 minutes left in your rebuttal.
Thank you. So I think we want to pick up sort of where we left off, and I don't want to keep repeating myself, but I think these are the central issues, so they bear some focus. You know, again, Tallahassee was never determined that commercial quantities exist on the site. They have not made the decision that they can extract minerals profitably. And under the plain reading of the definitions at issue, that means that we're still in a prospect. Second point is that we have never in any of our public statements claimed that we have commercial quantities of minerals, that we can extract those minerals profitably, or that we're done prospecting. Mr. Ferrier has said that the project is under development as opposed to a raw exploration project that has just begun. But if you look at the substance of our statements, everywhere we discuss the minerals, we characterize them as a mineral resource. We don't characterize them as a mineral reserve. We state that there are certain, aspects that we understand about the site. We understand where some of the minerals are, where most of the minerals are even, and what their concentrations are. But we never state that means we are ready to move forward with a mining plan in a mining operation. Again, as has been emphasized, this is a very traditional, straightforward prospecting permit application. There is nothing in the sense of a pilot project. There's nothing testing a new method of mining. There is nothing in the application that is innovative or new, frankly. It's just the gathering of core samples to do the kind of geotechnical studies that any prospector would want to do. And finally, this decision is not a decision that we should leave with prospectors who've operated the site in the past. It's not a decision we should leave with the appellant. It's not a decision I don't think that the division wants to undertake with respect to each new NOI application that it receives, if there is some indication that there are minerals present at that site. I think you heard the division say that this is a commonplace occurrence. There are, the state's got a long history of mining, and there are sites all over the state that have been drilled very thoroughly in the past. But for a modern company to come in the current context, what they need to do is collect their own data that they can verify, that they can represent is accurate, that meets quality objectives that are current and modern, that they can take to their financial partners and vouch for. They need to be able to do all of those things on their own, and they need to do it and represent to their shareholders that they have satisfied the due diligence necessary to meet their fiduciary obligations when they do that. They can't simply pick up where somebody else left off and say, well, we know that there were, 2,000 holes drilled in the 1980s, and that's good enough. That doesn't work. Each prospector needs to make this decision for themselves based on the current site conditions, based on current market conditions, based on the changes in technology that occur over the years. All those factors are at play here. And so we shouldn't be bound by a prior prospector's determination. Regarding the notice question, again, we've met all the notice requirements of the regulations. And I also want to point out, we haven't raised this before, but Tallahassee has made 2 separate presentations to the homeowners associations in this area just this year, where we've met with them discuss with them our plans for the operations. And, so as far as we know, we're going above and beyond in our public outreach efforts to make sure that people understand who we are, what we want to do at the site. We've also obtained and met with every surface owner where we want to drill and obtained their permission. We have the right surface agreement with each of those owners, which allows us to access those properties. And they certainly understand what it is we want to do. We've explained to them in detail. Again, Black Range and what they had suggested to do was completely different than what we're proposing. And I think you saw the graphics that the division just offered. We are not going to be extracting minerals for processing. We're not going to be extracting bulk minerals. We're at the most going to extract about 4 tons of material. And what we're going to do with that, again, is your typical geotechnical analysis. We're not testing a new mining method. We're not spraying water underground. We're not creating a large cavern. It's simply not a mining operation. I think I'd like to ask Mr. Brown to come up and answer some questions that you had with respect to the operations themselves. And let's see, Tim, I'm going to change seats with you quick because one of the things that, there's a lot of questions about the specific timing of the drilling and how that would be conducted, whether equipment would be left there. And we heard some presentation by the appellant earlier about the county use proceedings. I think a lot of those questions were addressed in very good detail in the county use proceedings. And the county did issue a resolution after those proceedings, and it just came out on January 10th. And so, I just want to note that in that resolution, for example, one of our conditions is that our campaign can only operate between the months of April 1st to December 1st. We're also required to stick to the hours of operation during daylight. So up to 6 hours, up to 6 days a week, unless we are drilling. Once drilling operations begin at a drill hole location, they will operate 24 hours a day until the hole is completed with a maximum duration of 14 days for each hole. And I have copies of that resolution if the board would like to see them. Unfortunately, it came out after the time for submitting rebuttal exhibits, but it's also, it's a published resolution by the county commissioners. It's the zoning law of the county, and it's publicly available. We are also committed to do a water quality monitoring program, and have already collected initial data. We don't have results back yet. We just started that program in November, I believe. But I'll turn it over to Mr. Brown to just describe some of the basic sort of day-to-day operational conditions that you might see if you were out there at the site.
Yeah, just to clarify a few points. The best time to be drilling up there are the summer months. We don't have to deal with winter, with cold weather, things like that. And really, as Mr. Middleton said, that window of opportunity is April through the end of November. And the way the process usually works is you can get the pads built, put some stakes out there on 2-track roads for clarification there. That reduces the cost for us to build roads. So we've got incentive to use existing roads as much as we possibly can. We'll build the pads. The reason we do that is you scrape the topsoil off. That's a valuable resource that we will use when we're done with the program, because we drag that back over, rake it out, and put seed on it. To clarify as well, at the end of the drill season, all the equipment goes off-site. The SRU unit goes away, the drills go away, the water trucks go away, because we don't want to pay standby time for those things to be sitting there all year long. So the idea is to you get in and do your project, and then the drillers go to their next job. So we don't leave any equipment on site. And in terms of the reclamation, I think the terminology is we do it as soon as practical. We're motivated to get it done as soon as we can if we don't need to go back to that specific pad and do any more work. We abandon the hole while the drill is there. Right, that's the time to pump the bentonite and the cement down the hole. Once they move the rig off site, if we don't need that pad, we'll reclaim it if we can, if there's enough time. But sometimes it might spill over to next year. The seeding gets done in the fall, so the seeds get covered with the snow and have the best chance to germinate. As Mr. Middleton said, the water quality is an important issue for us as well, in that we want to do everything we can to preserve that and not have any problems with it. And under the county conditional use permit, they determine the frequency and the analysis that get done, and we have to meet those obligations. We've already launched the program this year, collected samples from 4 domestic wells, and I think we've got 3 surface sample sites. Results are pending on those. I don't know what they are yet.
Yeah, and so just to wrap up with a little bit more on the initial, the resolution on the conditional use permit. These are some of the findings that the county commissioners, first of all, that the location and the use is compatible with the surrounding neighborhood. The use would not have detrimental effects on property values. The use would not impair public health, safety, utilities, or cause adverse environmental influences. The site would be served appropriately by the streets and roads that are there. That's all commensurate with the activities that we propose. And, you know, that if we comply with the conditions that are imposed, then our activities are not going to cause significant air, water, noise, or other pollution. So while that's a separate jurisdictional body, separate proceedings, I think that those findings go in large degree to some of the questions that have been raised here. And I know that, you know, the appellant participated in those proceedings, Ms. Sisson participated in those proceedings, and I know those issues were thoroughly discussed and raised in those proceedings as well. I think that's all I have. Do you have any questions?
Yes, Mr.
Madam
Moss.
Chair, I appreciate that the Fremont County said to operate, you can operate between April and end of November, I think. What was Parks and Wildlife's guidelines?
Same thing. Be aware of those, the capping seasons for the animals, and utilize best management practices.
Thank you.
Anyone else? Questions? Thank you.
Thank you.
Thank you. Really just a second to get a slide. Thank you. I think I can get started while he's doing that. So I just want to address a few of the points with respect to the previous order in 2015. It is true that there were 2 components to that ruling, but they were distinct. If you read the ruling, what you find is that the board found both that the underground borehole mining process constituted mining, and that the deposit had been investigated such that to an extent to prove that commercial quantities of ore were in existence. So it was not based just on the underground borehole mining, but also on the fact that they had already discovered commercial quantities of ore. You know, I understand that the drilling in this case is different than that. It does not involve that underground borehole mining, but there were 2 separate bases for that board ruling in 2015. I also wanted to talk just briefly about this conflating of the Australian Stock Exchange definitions of commercial with this board's development definition. I think you're going, to the extent the board adopts that philosophy, I think you're going to on a slippery slope. Essentially, it would based on the argument you heard, would require, what we heard was at least a pre-feasibility study, if not a feasibility study. That was the testimony you got from the applicant. That essentially wipes out that stage of development where you are further delineating an ore body. If you look at the board order in 2015, there had been a scoping study done at that point, but there had been no pre-feasibility study by Black Range and certainly no feasibility study. And as you saw on the slide that was presented, the definition for commercial viability at the Australian Stock Exchange is after that pre-feasibility study comes into play. So the prior board order completely contradicts that interpretation. And that's why I think it's dangerous to defer this board's definitions and statutory definitions purely to those stock exchange, stock and investment definitions and regimes. What was proposed was that whether something is commercial in commercial quantities is completely a subjective determination. If they think it's commercial, then it's commercial. If they don't think so yet, then it's not. I would submit that that makes it impossible under that standard for this board ever to find that commercial quantities of ore have been proven, because you'd be deferring entirely to the applicant's subjective determination. And of course, if they want to do sort of a speedy process, they're going to say, well, we're not quite sure yet. And so we haven't determined that, and we're going to apply for this prospecting permit. And I think the board would be binding the division in the future, regardless of the facts of that particular case, to a subjective determination of the applicant. And in this case, I think that's important, because here you have quotes from the applicant. These are their own words, that they're a focused drill program. That is, we're not talking about investigating a mineral deposit. Mr. Schultz said that if we were to interpret the rules as we're proposing, or the statute as we're proposing, it would wipe out investigating the mineral deposit. I would say the exact opposite is true. If you interpret it entirely subjectively, then you're wiping out the definition of development. Because certainly defining further the ore deposit by drilling could also be characterized as investigating the mineral deposit. And so there's got to be a difference there. You can't lump the proposal you're getting from the applicant essentially is to lump everything into everything is investigating the mineral deposit. But that can't be true if development is defined as defining further the ore deposit by drilling or other means. Surely that's some manner of investigating the mineral deposit. So I'm just cautioning the board that allowing the applicants to define whether something's commercial on their, purely deferring to their determination of whether it's commercial, and deferring to their determination as to whether you're in the prospecting or development phase is a recipe for eliminating those distinctions in the state law. And again, back to these statements from the applicants. Or from the record here. The County Planning Commission Director states that Tallahassee Resources submitted an application to conduct mineral exploration activities to further delineate the known uranium deposit and collect data. Again, that is strikingly similar. In fact, lines up perfectly with the definition of development, defining further the ore deposit by drilling or other means. That's what's going on here. You have a deposit that is well known, well explored, well delineated, and here we're going back in to pin down the precise details. According to the applicant, they say, well, we don't know what the shipping costs are gonna be. We don't know what the, all the details are gonna be on either side. The state definition of development does not require a mine plan to be in place in order for development to be triggered, in order for that operation to move past the prospecting stage. And that is essentially what they're proposing be the definition, is that until you have all of those costs, all of those expenses worked into a detailed mine plan, you can never be into this development stage. And again, I think we're in that, it's that slippery slope where you're losing the distinction between what the statute was meant to do. Yes, when you're out there looking for ore and you're drilling to determine whether there's something there that's worth a commercial enterprise, it's prospect. Once you've gotten to that stage, which I think is exactly what the definition of development says, and you're delineating that, defining further that ore deposit, you are now into the development stage. And in this case, I think it's, again, important because you have a whole, you have a neighborhood that was relying on a decision of this board in 2015 that further drilling out in this area would be subject to a mining permit. So they would have an opportunity to weigh in and be involved, have those baseline data in place before the approval comes down. And that was this board's ruling in 2015. So again, I'd ask that the board here respect that ruling from 2015, that independent ruling, apart from the underground borehole aspect, but the independent ruling that quantities of ore, the ore had been proven in commercial quantities, triggering the development definition. I did want to pin down some of these issues with respect to the wildlife impact. There was a statement from the division that the applicant had committed to a window of operations that was something like 60 days. And that was what Division of Wildlife had recommended. And my understanding was from the division's testimony that the applicant had agreed to abide by that. But then when the applicant came up to testify and presented the Fremont County conditional use permit, that 2-month window had expanded to a 7 or 8 month window. And so that's obviously an issue of great concern to the neighbors. Whether that commitment that was, as it was characterized by the division, is one that this board recognizes and the division recognizes, because I did not hear that same thing from the applicant. So in conclusion, I would urge this board to give careful thought to how you interpret those definitions of prospecting and development, and not defer entirely to the operator, because I think you'll find that that's a one-way street. Everything will be prospecting until they want it to be developed, until they submit that mine. I think the statute is set up to have all those definitions: prospecting, development, extraction, and production, to show that time frame. And so squeezing development into production or into mining those further stages, I think eliminates the protections that are meant to be in place for the public with respect to the notice and particularly the water quality. So Skip, I'd love it if you had something else to say. Otherwise, we can.
Well, I think as I said, I mean, we knew that they had ruled that commercial quantities exist. And the way, candidly, I see the law, it doesn't say commercial quantities exist by this operator. It says commercial quantities exist, and that was a ruling of this board. And I get that what's going on in here as it relates to, we don't know that. Well, I'm sorry you don't know it, but the reality is this board ruled that commercial quantities existed. It wasn't that commercial quantities existed for Black Range, but not for Tallahassee. So that's my confusion on this. I think there's been a ruling, and to me, this is a matter of state law. We counted on it. We built a house.
Can I ask a question? And maybe I should have asked it of the operator, but they mentioned that there were 2 presentations to the HOA this year. Did you all attend those?
There was one, it wasn't this year, by the
Well,
way.
right.
Yeah,
This past
you
year.
probably knew
2023. Is
that.
that correct? They were both in 2020.
There was a presentation at the HOA that said, we plan on, Mr. Brown did, so we're planning on drilling. He didn't take any questions and he scooted out of the room. And then this week, we've got issues where our POA and our South T-Bar Minerals people are on the board. It's kind of crazy town out there, as you can imagine. And so
Is
we,
POA Property Owners
Yes, ma'am.
Association?
yeah, it's like an HOA basically.
Uh-huh.
And about 3/4 of the members on the POA are also on South T-Bar Minerals. Yet only South T-Bar Minerals has about half of the landowners are mineral owners as well. So there's all kinds of chaos, as you can imagine. But it's been all real secretive, so we couldn't rely on that board. They're the ones that said, don't worry about it. It's, it'll never happen kind of thing, right? But anyway, did I answer your question? I'm sorry.
So asking what the stakeholder outreach
Yeah,
was
so-
to the HOAs.
Yeah, I mean, and then Mr. Brown worked with the POA on this in the January quarterly chat. He wrote a letter and made statements that he's going to drill 10 holes in the next, between April and November over the next year. And then they'll let us know when they're going to drill the rest. Which again, isn't lining up to everything we're hearing in here. That's all I have.
Thanks, Madam Chair. Mr. Parsons, good afternoon. Help me understand this a little bit about that last board order. And I think I'm trying to understand your comment about, prospecting would be a one-way street with this operator when it seems like the process actually worked the way it was intended the last time around, that this wasn't the 2015 ruling was not just a standalone NOI to conduct prospecting operations, but was to approve an application for a third modification. And so so as I sort of understand that process back then, you had an NOI to conduct prospecting operations. Those prospecting operations were conducted. They came in for a second modification at some point. I'm assuming they conducted those operations, and then it was the third time that it came in, and then the board said, okay, wait a second, now what you've gone from, they actually were the stopgap to say that you've gone from prospecting, and what you're doing here now is more mining where you need a reclamation permit. So I'm trying to rectify that to this, because it seems like that process worked. And it does seem that it's exclusive to the operators. So you have one operator here, and I don't think the board, I'm not understanding where the board actually ruled that commercial quantities exist. I think what they were ruling, if I understand this correctly, and you can correct me if I'm wrong, was that Black Range at that time, given what they have done, have essentially been able to establish commercial quantities exist. And then they were pulling up some of the statements that the organization was making. And back then, I think that there was they quoted that, what was it? It was 90 tons. I saw on one of your slides, it was 22 tons, I guess. it was 90 tons, something like that. It's not that I don't see that the board actually, as a board, we don't get to make those determinations, I don't think, unless I'm incorrect.
No, I don't think the board is in a position of determining how much resources are. I would say that, of course, Black Range came in here and argued that they were still in the prospecting, that they hadn't figured it out either, right? I mean, they said, all we have is a scoping report. That's not enough. You know, they're always, and then their press statements are strikingly similar to the ones that you see that were cited by the board, are strikingly similar to the ones that you see by the applicant here. It is true that they were on their third modification of their prospecting permit when they did that, but they were still arguing that it was prospecting, you see. And so my concern again is that to the extent we're deferring to an operator as to what's commercial, making it entirely subjective like that, you're wiping out this ruling previously, in my view, because in that case, the board said, look at these statements that the company has made, that the applicant has made, and they say they found this much ore. They say that they have a thorough understanding of the deposit, and they're doing further defining the ore body, doing delineation drilling, and that's where basically we are here with this operator as well. They're saying they're doing delineation drilling. They know where the ore body is. They're going in to fine tune it. I understand it was a different method that Black Range used with that underground borehole mining, and I'm sure that didn't help them because that's certainly more concerning operation to carve a big cavern in the aquifer, essentially. However, the database, the information out there in the world that this ore body is well defined, well known, and is known to contain commercial quantities of ore is the same then as it is now. And that's the definition of development. I mean, that is what it says.
Do you fine tune it with 20 bores though?
Sure. Okay, yeah, that's a delineation drilling program. It's as is in the record from the county.
And where do they have the records for the other 2,000 bores and the information that came from those?
Well, they indicate that there's extensive I mean, here's some evidence of it. This is from their document. The fact that they haven't drilled their own hole out there doesn't prevent them from having what I would characterize as a fairly precise characterization of the entire ore body at the Hansen site, including the depth and the parts per million of uranium oxide.
I think that maybe the question that we're trying to connect here is to say that these two conversations are apples to apples to the 2015 conversation. We're asking, is it really if previous operator, their permit starts in 2009, so we're coming 4 years into that, they've got an approved NOI, they came back with some modifications, and what was denied was modification number 3 and the type of drilling, whereas this one is the initial application for notice of intent by a new operator because they do not possess the data. So I'm not exactly sure that it is characterizing it correctly to say that this is the same conversation, or that the board would be going back on a conclusion that was already made, when that's a conclusion that was made on a third modification to an approved permit. This is a new application for a new notice of intent permit by a new operator.
I certainly acknowledge that distinction. I would say that if you read the board order,
Yeah,
I'm not,
I'm looking at it.
I'm not sure that it relies heavily on the fact that it was a third modification. I think it was more or less, look at the statements that the company is putting out there demonstrating that they have a fairly robust knowledge of this deposit, and they know that there's commercial quantities.
Sure, and that company was Black Range Minerals.
Correct. Which we now know is part owner of this deposit, still has an interest, as was testified. So it's pretty interlaced. And my concern is, as soon as a company is told that they have moved to development and can't prospect anymore, if it's their interest to continue that prospecting, all it takes is to shuffle around some corporate entities, and they could be right back in here saying, well, we don't know. That was the last guy.
Which is exactly what is happening, right? They're,
Yes,
they're
I'm
top,
just
they're top
wondering-
in.
Prospecting, if it's not development, not making any money.
Yeah.
Well, you're making money on increasing the stock price and selling your shares.
It's really expensive. With all due respect, what strikes me here is in Black,
Yeah, Black Range.
yeah, Black Range in 2015 walked away. There's nothing commercial out there. There's no mine, there's nothing advanced beyond that. So new owner, the sad part is for mining companies, they get to do this rinse and repeat way too often. And it costs them a lot of money to do this sort of work. So they don't, I have never met a mining company that wants to prospect more than they have to be able to ascertain to their investors that they have something that can perhaps at some point move forward. But there's huge gaps of nothing commercial happening out here whatsoever. So that's the only thing that just doesn't quite align for me, is saying that they're wanting to do this to be kind of a pain in the ass to the neighborhood. I don't think that's the intent at all.
Certainly, I understand that perspective. I would submit that there is a tier of mineral companies that make a living on purely exploration. And that's all they do, is explore, try to get some bump essentially, and then offload those properties. And so, it's a complicated environment, obviously.
Yes, absolutely.
But I'm not sure that the fact that the previous company walked away from this project is conclusive. In fact, the board found exactly otherwise, that it was commercial.
Thank you.
Any other questions from the board? No?
Thank you for the engaged discussion. I really do appreciate the thoughtfulness of this body.
Thank you. So.
Yeah.
Great.
Yeah, ready to discuss.
Okay. So at this point, we have heard the deliberations from all of the interested parties. We will close testimony. That means that the interface between here and there, I think sometimes there ends up being a question comes up where you may ask the division to just clarify something, but really the intent is to have the discussion up here amongst the board members to kind of weigh out the options and have that discussion. It's no longer open testimony. Anyone kick it off with any thoughts there? I'm gonna reread the staff definition just so we all know where we started. The staff recommendation. So staff is recommending that the board deny the petition for appeal and affirm the office's decision to approve the Tallahassee Resources Exploration NOI file number P-2023-115.
Feel like there's been enough transparency at the local level and at this level. Getting the Board of County Commissioners informed and going through the conditional use permitting process, that's something, that's a process, right? Like it's not something to take lightly, or if you're not serious about seeing and having your own data as a new company, a new permittee, right? So, yeah, that's kind of where I'm landing with it all.
I think that really helped me as well. I know I drilled Mr. Kazir on the, like, what it would look like, but I think then hearing what Fremont County really did outline in that conditional use permit made me feel more confident that, you know, you're not having someone do a little exploration, walk away, oh my gosh, we're snowed in, oh my gosh, we can't do this, and those are some of the issues we've run into sometimes before, but I think that the fact that the process really has spent quite a bit of time in front of the county made me feel more confident in some of those answers around an NOI, even though that process doesn't always have as many guardrails in place initially, at least as a formal application. I think the county's got some pretty significant guardrails in place around it.
And on our side, annual reports, right? Like there's gonna be a communication line as the process goes on continually.
Yeah. Thoughts? I don't want to switch topics too quickly. Anything else on kind of the county CUP, CPW side of oversight or due diligence?
I have a question for maybe Tim, if he may.
I think so.
So the, when you talk about the abandonment reports, and it's due within 12 months, is that regulatory, or why 12 months? Why not?
12 months is a good question. That's written in the rules, specifically.
So that's.
I suspect it may have something to just time to process all the information and get it into report. But I don't know what the basis for the 12 months is.
Is that typical what you see on these projects, or is it usually quicker?
I push all the time to make it quicker so they don't forget, but sometimes it's like the 11th month. Sometimes it even's the 13th or 14th month, because I'm calling them, you know, every other week. Hey, where's that report? So.
Thank you.
And then I think, you know, the other big topic was just the difference between prospecting and development. So how we feel about kind of what was presented, the understanding of that, what this project scope looks like in that sense.
Yeah, I'm leaning towards the staff recommendation. I'm not seeing enough evidence for us to overturn them, and I think Ms. Nelson's parting comments there really kind of also were along the lines that I'm thinking about. I mean, this looks like prospecting. It's 20 boreholes. What's the other term? Core. Cores being pulled out of there, and you're not making money off this. It's not pulling out something that's going to be processed. So I don't know what isn't prospecting beyond that. I mean, that just, and I get the concerns. Don't get me wrong. I get the concerns on a fundamental level, but jurisdictionally, I don't have the pleasure of taking in concerns about the bottom lines or speculation or business dealings or those type of things. I will say this, I appreciate the operators reached out. I would encourage you to do that above and beyond. This board likes to see that. Regular communication goes a long way in working with your neighbors, and this area has neighbors. And from prospecting, if this does go somewhere else, you've got a long way to go. So I think we're at prospecting right now, and that's how I see that.
Arn, any thoughts or observations from you?
Well, I certainly learned a lot more about definitions of a lot of these words, and it's definitely gray in some places, but I am comfortable with the staff's recommendation. Going through all those definitions, I feel comfortable that this is prospecting and that we will have a lot of opportunity to make sure things go well as possible. So that's where I am.
Thank you. Any other thoughts here at the table?
No, I definitely see that this is prospecting. And there's a problem when the prospecting process continues. I can see how annoying that would be, but there's nothing we can do about that. They could sell the company out the door. I mean, the minute they step out the door, they could sell the company and a new one could come in and say, we want a prospect. So by definition, I think it's prospect.
Final thoughts, or someone want to entertain a motion?
I would move that the board deny the petition for appeal and affirm the office's decision to approve the Tallahassee Resources Exploration NOI file number P-2023-015.
Second.
Second, any discussion? All those in favor signify by saying aye.
Aye.
Those opposed, same sign. Okay, hearing none, the motion passes. Thank you all very much for your time, for your commitment to the conversation, for being there, and I do encourage you to all continue to keep open lines of communication moving forward, no matter what. Thank you. Please drive safely back. Okay. We have, where are we here?
Madam Chair, if I could real quick. When we revisit the regs, can we revisit maybe the public notification timelines on this? This is another one that I get it in a different time, different place, but
Duly noted. Yeah, I have it on my notes and we actually, back in 2007, 2008, when we, this process and stuff, that's when those rules were they were put into place. That was when we removed the cloak of confidentiality from Hard Rock. So, so it's been that long and stuff and that, but that was a process and stuff that was put into place during those rule makings. So, and we looked at our website and we can find the NOIs quick enough, but I also see where we might be able to do an improvement and stuff there to make it a little bit more forward. And that's an easy fix for us and stuff up front. So, but yeah, it'll be on the list.
And my other note from the list, and I understand like when you're talking about it from a technical standpoint, it makes sense to use the word abandonment.
Yes.
But I would say to the layperson kind of skimming through a process, thinking about something, maybe just some clarification. We kind of wordsmithed a couple other things in the Hard Rock mining side of things that internally you knew what it meant, but it just didn't feel very good when you said it. I think we talked about token. I think token was the word.
Yes.
And so just a note there of, in this sense, abandonment is a good thing with the proper way of going about doing something, but in this, we have an abandoned mines program and then we're asking people to abandon a core sample.
Sure.
You know,
Yeah.
so I just.
Yep,
wrote that.
there's some room for improvement there.
Yeah.
For the lay person that
Yes.
doesn't deal with these mining.
Exactly, exactly. And I think the more better of a job we do of making these things publicly available, the better we need to be. If you're skimming through and you're looking at, oh my gosh, what's the process for this? And you see these ones are connected, scary word.
Yes.
You know,
No,
oh my gosh, because I mean, yeah.
Have rules.
We have, yes.
You must.
What we didn't say was.
Okay. Is there, well, Jeff and Rachel are getting ready. I just wanted to tell the board that next month is our annual training that we have to go through annually. Jill is already grimacing and stuff like that, but depending on the schedule in that, on some of the board items, we have one or two of them that if they go away or they're postponed, it makes it a one-day deal where we'll do business in the morning and then take care of the training in the afternoon. But if we have a couple of big ticket items and stuff, kind of like we had today and stuff, that's probably gonna mean that we'll do our training on Thursday morning. So so just you're cognizant of that. We'll do our very, very best and stuff to try to keep it to the one day, but it might be a long day. But we don't wanna, at 4 o'clock in the afternoon, be talking about rules and regs.
You always pick the week of our school break. Both February and April.
Yeah, well,
Just saying.
We were trying to say.
that's why it stayed,
Just
because
for that.
3/4 of the other people are in March, so we
Really?
steered a clear away.
Well, what happens to those of us when the state passes the thing that says you have to use all of your PTO?
Yeah.
And the thing that you're obligated to, mean you can't use your PTO, and then you get a slap on the wrist at the end of the year because you didn't use your PTO. Same state did the same rules, so just a little alignment here. Okay, take my vacation.
Yeah, well, if you can't make it, we'll do a one-on-one just to make sure.
No, it's fine. I'm giving you a hard time, but I have put in a calendar request.
Okay.
With regards to this last case, would there have been an opportunity to maybe work more with Fremont County? I mean, I know that's not what we're ordered to do, but it seemed like Fremont was doing one thing and we're doing another. Is there an opportunity to get to the
Sometimes
public
stuff
better?
we have interaction and stuff with the counties and stuff, they may reach out to us and stuff if there's a particular concern on a CUP or something, but typically we stay within our own boxes and stuff because the jurisdictions of the locals, and that their focus is way different than ours. I always like to point out, if something is gonna happen, we say this is what has to happen to reclaim it, but it's the local level and stuff that says whether it happens or not anyway. And so in any,
I just meant, that the public be a little bit more aware of what we're both doing.
yeah, and that, so yeah, this one is something found out through the CUP, a lot of times the stuff that the counties don't find out about something until it's in front of us.
Yeah.
And so it's a kind of a give and take thing. So.
Most of the jurisdictional things that the public faces actually fall more within the county budget.
Yes.
Yeah.
And it was actually unique, because I think this is the first time that I've been involved where the county went first.
Yes, that was kind of.
Because usually it comes to us and we've got complaints about transportation, noise,
Wildlife.
the character of the neighborhood, and those are things that don't fall within our jurisdiction.
And that's the way I understood it.
Yeah.
That's why this seemed kind of peculiar.
It's not mandated one way or the other. I mean, I think, maybe for an NOI, but had this been a full mining application, a lot of times they will come to us first because it is such a complex layer of issues. They're gonna have to go through it anyway. And then bring it to the county and say, hey, we hashed through this, and so. here's what
I've got
we present
this
to you.
permit to do this.
Yeah, I don't, but it's not mandated who you go to.
Some
Okay.
counties actually, lean on our expertise, if you will, for the mining part of that. So they actually prefer, and in fact, I think there's a couple of counties and stuff that require that they come to us first. We don't require it the other way, but they require stuff that they get the DRMS permit first because of the technical aspects and stuff of that are looked at first.
See, we all cleared out.
How long is that county process? I mean, they had their.
Better than winter, eh?
Breathe now, October, when might everything got started, is it pretty quick or is it?
Yeah, I mean.
We're still on the record. We've got a lot of conversations going on. Can we stick to one, please?
It can depend. I mean, it can take 2 meetings to kind of work through it. The bulk of it, that's with the county commissioners. The bulk of it, though, can be probably with county staff in that that's a 1 to 6, 12-month type of deal.
Through land use.
It's
Yeah,
not
land use. It may not, depending on the back and forth that they have to get it to a place where they can then bring it into the commissioners. Yeah.
Because that's to go through a planning commission and then the board of county commissioners.
Yeah, and just the staff doing their regs and making sure that things line up. And that's the longer process than both of them.
Okay. Good question. So we are on item number 8. This is a staff information education item about the mine subsidence protection program. And Rachel Nicholas presentation.
Hi, I'm Rachel Nicholas. I'm a project manager with the Inactive Mine Program. And I'm also the program administrator for the Mine Subsidence Protection Program for the state of Colorado. And I'm here today to give you all a background on what the Mine Subsidence Protection Program is and the MLRB's roles as trustees of the program and what that looks like. So, today I'll go over mine subsidence, the definition, the causes, types, and subsidence factors. And we'll be looking at the Colorado Springs undermined areas as examples of what we look at when we see neighborhoods that are undermined. We'll discuss identifying mine subsidence and then the mine subsidence protection program itself. Sorry, I'm a little nervous. Who's eligible and the enrollment costs and coverage and the roles that the board has within the program as trustees and the agreement that the MLRB is regulated by. So mine subsidence is defined as the movement of the Earth's surface caused by the collapse of underground mine voids or entries. Here's a photo, just an example of mine subsidence at the ground surface. And this is an example, a good example of trough subsidence, which we'll talk about in more detail. Mine subsidence is caused by voids that were created by removing coal and rock during mining activities. Gravity and the weight of overlying rock cause layers of rock to shift and fall downward into a void. As one layer falls down, the void moves toward the ground surface. As the depression reaches the surface, it can cause holes, cracking, tilting, and sacks at the ground surface. And this can occur abruptly or gradually. There's different types of mine subsidence. This is a diagram of trough or area subsidence, like what we saw in the first slide. This occurs where a large panel of coal was mined or where several adjacent pillars have failed. So if you look at this diagram, you can see at the bottom layer is where the coal is. So that's where the mine workings were. And the ground was weakened as the material was taken out. And eventually the ground will move into those voids that were left behind and propagate to the ground surface, creating depressions, settlement, and can, as you can imagine, can wreak havoc on the structures that are on the ground surface. And on the photo shown here is just a little example of trough subsidence in a roadway. You can just see the little dip there, and that was due to either the pillars failed or the roof of the mine failed. Another type of subsidence that we see is chimney subsidence, and this occurs as caving allows voids to migrate upward from the mine and creates potholes or sinkholes at the ground surface. And the holes are usually circular in shape, but can be different diameters and different depths. And here's another diagram that shows chimney subsidence. And here you can see that it's caving into one particular area and propagating straight up through the overburden into a circle at the ground surface. And here's some photos of examples of those. what it looks like at the ground surface. Different factors that affect mine subsidence and where it occurs are depth of mining, the age of the mine, geometry of the mine workings, which can be the width of the panel or room that was mined out, and the dimensions of the pillars that were left in place. The extraction amount, the amount of coal and rock taken out can affect subsidence. And the thickness and nature of the overburden, what materials you have between those mine workings and the ground surface. If it's a solid bedrock with no fractures and as opposed to a weaker bedrock with weaker layers, that can obviously change how that rock reacts to mine collapse. And the presence of groundwater or lack of groundwater can also affect mine subsidence and surface loading, the different structures and weight that are loaded on the ground surface and how that affects the subsurface. So this is a map of the Colorado Springs area. There's two main neighborhoods in Colorado Springs that are affected by historic underground coal mines. And this is east of I-25, and we call this the Cragmore area. And this just shows you the extent of mining and the neighborhoods that are located within those areas. And just to give you a little information. Oh, and there's also mine names on this map, so you can see that there were a lot of mines. This is that same area, and on this map, sorry if it's hard to see. This shows the different hazard levels in the Cragmore area. And these hazard levels were determined by an extensive subsidence study that was completed for DRMS for the Mine Subsidence Protection Program in 1985. And they used those factors that we just looked at, the different factors that affect subsidence, to come up with this hazard level. So like the depth of the mining, the conditions of overburden and those things. And so we have from high to moderate to low to very low. And the red dots on this map are all of the features that the DRMS inactive mine program have addressed and done mitigation at. So subsidence that we worked on either through our program or previously through the Office of Surface Mining Emergency Program.
Would are those just individual homes or kind of locations?
It's a little of both. So you can see this group right here is lined up very much in the formation of a neighborhood, and that is individual homes that were grouted under a program that we did due to a lot of subsidence was happening all at once. And so we did a more proactive program. Instead of mitigating, we compaction grouted every house in that area. And the dots that are just kind of randomly around, those could be sinkholes that opened in the street, or sinkholes that opened in people's yards, or homes where we had to do grouting because they were experiencing effects from mine subsidence. Did that answer your question?
Yeah, thank you.
Okay. So this is a good example of what mine subsidence looks like. Sorry, it looks like the polygon that I drew from the map is not lining up with the aerial. So sorry about that. If you look closely, you can see the subsidence at the ground surface, the circles, the chimney subsidence in this aerial photograph from 1947. And it comes all the way down here. And then you can see that same area here in this picture in 1960. And then here is the same area in 1979. And here it is in 2009. So this is why we have the mine subsidence protection program. Okay, so here is the Rock Rimmon neighborhood, which is the other of the two neighborhoods I was telling you about that are affected by mine subsidence in Colorado Springs. So you can see, sorry, I-25 here. And then this is the Rock Rimmon area and the extent of mining on that side. And here it is with the hazard level map. And you can see a big difference on this map than the Cragmore map in the hazard rating, which is mostly low here to very low all up here. And there are much less areas that have been mitigated through DRMS. And that is based on that same extensive subsidence investigation that was completed in the 80s. And the depth to the mine workings in this area is very great. So that the deeper you go with the mine workings, the less likely you are to see subsidence propagate to the ground surface. And the more shallow the mines are, like that Danville Park photo that we just looked at, those mine workings are very shallow. So that makes a big difference. Okay, how to tell if damage is mine subsidence related. First, we look at, is the property undermined and is it really settlement as opposed to another cause. So to, come to a conclusion regarding whether or not it's subsidence, we check the pattern of movement on the entire structure. We check the foundation type, if it's slab on grade floors, and they're heaved in the middle and down around the edges. That's generally a sign of swelling soil damage. It may not be mine subsidence. Many undermined areas in Colorado Springs also have near surface swelling soil problems. And we also review regional subsidence risk studies and review regional studies for other geologic hazards like landslide susceptibility, swelling soils, and swelling bedrock too, or heaving bedrock, and collapsible soils. So here's a diagram of a home just to show how swelling soils movement can affect a structure. And like I said, you can see the slab, which this is a basement, but it's heaved in the middle and down on the edges. And then through this beam, the damage will go to the other floors in the house because there's no space between the beams and the floor joists. So other processes can cause settlement of structures and improvements, poorly compacted backfill around foundations and utilities, piping of soils along utility trenches due to waterline leaks or breaks, collapse of abandoned septic systems, and hydro-compacting sand or silt soils, which is why it's really important to review the many geologic hazard studies completed for the state when determining whether something's experiencing mine subsidence. So here's an example of poorly compacted backfill around a foundation. And we often see that over utility trenches as well. So that can cause settlement to a structure. And here's a diagram of a collapse of a septic tank. So, and here's actual mine subsidence. So a careful examination of the damage and damage patterns should be looked at by a professional geotechnical engineer. It's often necessary to determine if mine subsidence is occurring. So this hole was kind of cool. It was just a It was actually initially a huge sinkhole in the middle of the street. Colorado Springs, the city tried to fix it before calling me. And it didn't go well, as you can see. So we went back in and fixed it up, excavated it out and filled it with concrete. So,
Question,
yes,
do we perform the professional geotechnical engineer or do we contract that out?
we contract that out. The MSPP contracts it to a geotech engineering firm through the request for qualifications process.
Do we ever get a second opinion or we go with the one contractor?
Well, we
We have.
gotten second opinions before, yes. We have only so for the program, it's hard to have more than one geotech for the program because they're completing several or many inspections, and they're housing all of that information, and they're also doing follow-up inspections. And I guess we've never really tried to do more than one engineering contractor through the RFQ.
We haven't in certain circumstances, not necessarily through the RFQ process,
Yeah.
but we did at a number of residents where there was some uncertainty as to the findings of the initial geotechnical investigation. We did contract with a separate engineering firm to provide an alternative evaluation. Generally, there's an initial evaluation made by staff and then potentially a geotechnical engineer if necessary. And then if that determination is inconclusive, like we can't really figure it out, then we may contract out or have additional information collected by a geotechnical engineer to arrive at a conclusion. So it varies, it's situational depending on what our initial findings are for the site.
But is that our responsibility if it's a mine that was built in 1890? I mean, those in Colorado Springs, I mean, they showed a picture in 1947. The population of Colorado Springs in 1947 was maybe 35,000 people. So when they were doing their mining, it was out and about. It wasn't in a residential area. It's now the residential areas come on top of the mines.
I think it's a legitimate point and a legitimate question whether or not it's our responsibility. The Office of Surface Mining did provide the state an initial grant, and she'll be covering that shortly, to set up a program to provide insurance for homes that were constructed over areas where historic mining did take place. And so whether it's truly our responsibility or not, there was a program initiated by the federal government to provide funds to the state to support homeowners that have homes constructed over existing historic mine. So based on that, through the trust fund, we do have an obligation for homes that are considered eligible to conduct investigations and determine whether or not mine subsidence is impacting the home and whether or not the damages associated with that would be covered under this trust fund or this protection program that's like insurance, not exactly insurance, but so I don't know if that fully answers your question, but
I know more than when I asked the question.
And how do people learn to build over this? I mean, this doesn't happen so much in West Virginia and Kentucky.
Well,
I mean, I'm sorry.
It did.
Well,
It did.
They have subsidence insurance there. I mean, left and right?
Yeah.
I think a lot of it is just builders love cheap land. And land is pretty cheap.
it's municipalities and land use.
Counties love
how they-
property tax revenue.
Oh, yeah.
Trade-offs.
This picture is terrifying. Let's build on landfills too, while we're at it.
That's been.
There's also that big project that's built on landfill right along Highway 24. And I actually think they've done a pretty responsible job with that, but maybe as I speak, something will fall off into Highway 24.
And I think Rachel will cover in the remaining portion of her presentation, the eligibility requirements. And there are some restrictions on who can be covered. And there's some reasoning behind that. And I think it kind of hits at your question on who's responsible for homes that are constructed over this. So. Let you continue.
Thanks,
Sorry.
Jeff.
I
No,
use
thank
that
you.
realtor.
Oh, so now we're here. The Mine Subsidence Protection Program, it was established in 1989. It was funded by a one-time $3 million grant provided by the Federal Office of Surface Mining. The grant money comes from a federal reclamation fee collected per ton of coal mined in Colorado, paid by the coal mining operators. The program is intended to address mine subsidence resulting specifically from coal mining. To be eligible for the program, the structure must have been built prior to February 22nd, 1989. That's the day that the board developed the program, or, and so they set that as the cutoff date. So like what you were saying, to maybe encourage builders and developers to do their due diligence when building in abandoned mine areas, and also to hopefully encourage the counties or the cities approving building permits to require the builders and developers to do their due diligence. Don't know if that works, but. So, and obviously the structures must be located in an undermined area. Multi-residential complexes up to 10 units per building can participate, provided that every unit in the structure is enrolled in the program.
So 9 people could have it. And
Yeah.
Better be
And
friendly
we
to
have
you.
that.
Of course.
We have that situation.
This is
It's really fun to go to those HOA meetings, let me tell you.
Wow.
So we have a 1-800 number. That's how our main point of contact for people to enroll in the program. If the structure is eligible, we do a baseline inspection, determine if any pre-existing damage exists currently. And those pre-existing damages would not be covered. Is that okay if I do this?
Or you can minimize.
Oh, okay, I'll just do that. Sorry, excuse me. The cost of the baseline inspection is included in the first year enrollment fee of $235. So the inspection fee is $200. And continued participation in the program requires a $35 annual enrollment fee. After receipt of that $35 fee for 3 consecutive years, there are no further fee billings. The program is transferable with not having to complete a second inspection. If the home is sold and the program is transferred in a timely manner, then they will not have to pay that enrollment inspection fee. So it saves a little bit, but they still have to pay a $35 transfer fee and 3 yearly $35 payments. And then if a mine subsidence event were to occur that caused damage to the home, they'd be covered up to $100,000 with a $1,000 deductible, or a maximum cumulative benefit due to subsequent subsidence events equivalent to the fair market value of the eligible property prior to subsidence.
Is this a disclosure? Like if you're selling your house, is that
No,
I've got levies paying, I've got a limited subsidence?
no, it's not legally required to disclose.
Of course not.
Why would you? I mean, it should be, shouldn't it?
Okay, Colorado Springs is off my list.
Just call me before you buy anything.
Declaration, she will tell you if it's okay.
Yeah, I don't want the.
But
So-
the 3 million, unless you're gonna touch on this again, 3 million doesn't seem like it go very far. So I mean, do we put it in a trust fund here, or
She'll hit on it.
I'll hit on the status of the trust fund and some discussion points with that for sure. Very quick, very soon. So the claim investigation process, I thought I would just give you an idea of what that looks like, because we have a lot of claims, especially in Colorado Springs. So I would start with initial in-house research, which includes the Dames and Moore, which is that extensive subsidence study that I was telling you all about. That was completed in 1985 for the Mine Subsidence Protection Program, and that was done for Colorado Springs and also for the Boulder Weld coal fields. So we cover those two. I just focused on the Colorado Springs today, which gives us our hazard rating, locations of shafts and other features that might be a higher risk area, and the depth of ground cover between the ground surface and the mine workings. And we'll also review the mine map, the workings and the shafts, and we have all of our historic coal mine maps geo-referenced, and we have all the vector data from those geo-referenced mine maps, so at our disposal for inspections. The site inspection includes inspecting the structure, documenting all the distress and damage, inspecting the soil for cracks, for cooling water, anything out of the ordinary. We look at recent weather events that can have a huge impact on geologic hazards, landslide susceptibility, swelling soils, subsidence, when you get a lot of moisture, or the opposite, if you have prolonged drought, can really affect things, cause settlement. And drainage related to the foundation. Make sure all the site drainage is, stormwater drainage is not pooling next to the foundation and is being directed away. And then we'll go through all the site historical information, look at all the OSM emergencies that have been completed, any subsidence investigations in the area, claim history for the property and the surrounding neighborhood, and the construction age and type of foundation. And the conclusions is probably the most important part of the claim investigation. And these conclusions are based on a preponderance of evidence, since we can't see underground. We use all of those tools that I just explained, and based on a preponderance of evidence, come up with a conclusion on what mechanism is likely causing the damage to the structure. And our conclusions also include explanation of those other site factors that may be contributing. And sometimes further investigation is required because we just can't tell what it is. And in those cases, we would go forward with a geotechnical investigation, which would include drilling. And those are developed and designed for each individual case. We don't have like a blanket investigation process. Those are specifically designed for each house. And then the homeowner is given the option to appeal any conclusion or decision made by DRMS to the board. And so that's where you guys come in. And a participant in the program can appeal to the Board of Trustees under the following circumstances. In the case that a participant is expelled from the program due to delinquency of more than 90 days in payment of the annual administrative fee, the expelled participant may petition the board for a waiver of the reinspection requirement for readmittance. A participant aggrieved by a claim determination of the division or the plan administrator concerning the proximate cause of damage, the amount of benefit appropriate to particular subsidence damages or related issues, may petition the board for review of the determination. The decision of the board shall be subject to judicial review pursuant to 24-4-106 CRS 1984. Other board roles include you can determine to defray the cost of inspection for a homeowner, modify maximum benefits and deductible amounts, amend section 8.04.3 of the Colorado Mine Rules, payment of benefits in Rule 8. And that's all included in your board packet, Rule 8. Receive and review yearly report on the status of the program from the program administrator per the example in your board packet of the 2023 yearly report. And then really quickly, I'll just summarize the agreement. This is also in your board packet, but this is just kind of a summary to give you an idea of what the agreement has. So Article 1 describes the initial funding and additions to the fund. Article 2, income and principal, defines beneficiaries, benefit payments, and benefit vouchers, discusses trust sufficiency, termination, and excess funds. Article 3, trust administration and protective provisions, defines parties, restricts distributions, outlines governmental function of trust, compliance with anti-discrimination and unfair employment practices, public meeting requirements, majority decisions, exoneration of persons dealing with the trustees, non-waiver of immunity. Article 4, powers of trustees, management of the initial grant through the trust, fiduciaries Powers Act, delegation of powers. Article 5, trustees and reports, defines trustees, corporate and co-trustees, resignation, removal and succession, rights of successors, compensation, successor, corporate fiduciary, and outlines reporting. And then Article 6, amendment, Article 7, revocation, termination, and Article 8, rules of construction and applicable law. Do you guys have any questions so far? All right, so here's the, we'll get into the trust fund. So our current balance is a 4.9 million. And I'm just a graph to show you expenditures versus revenue. So the expenditures are blue, revenue is orange, 2015 to 2023. And I mean, there's no real pattern here. It just depends on the number of claims we get, the number of claims we pay out. Well, there's a lot of factors, how much we're collecting in interest. And so not a great pattern to show you. And then here's the collected revenue through 2015 through 2023. We did have some better years, 2019, 2020, likely due to the interest earned.
And that's mainly all interest.
Mainly, yeah, because the fees are negligible.
Yeah, $3-5 doesn't add up fast.
So, and here's the trust fund balance from 1985 to 2025. So, we did good for 15 years or so, and then it's just kind of bobbed around there at the 5 million mark since about 2004.
And I'm sorry, is that because we're paying out so consistently then, or?
It's probably most likely due to the increase in costs for the engineering services.
Yeah, the cost for a claim inspection went up significantly over the course of over 30 some odd years, 40 years that the program's been in existence.
And drilling, geotech inspections, investigations, excuse me, have the cost has increased significantly.
And so I think there's some question, and this is probably something to pose to the board at some point in the future, is are the fees associated with membership in the program appropriate for maintaining the trust fund long-term? And I don't think we're prepared to have that discussion today, but just some things to consider as trustees for that fund, recognizing the remaining liability and risk associated with all of those homes in those areas constructed over mine subsidence. So how do you ensure that the trust will be there to cover all of the existing claims into the future? And is there a better way to manage the fund to ensure kind of long-term stability? Because at this point, there's no anticipated additional funding from the Office of Surface Mining, Reclamation and Enforcement for adding to the fund. So it's through either management of that fund in terms of seeking alternative investment opportunities, which I believe is allowable under the rules associated with the trust, that you could seek outside investment beyond the state to increase the return on that investment. Or the other option is to increase fees associated with either entering into the trust fund or the program, or maintaining your membership in the program. So some things to consider.
Are there a lot of people that know about this? I mean, I don't think so.
Part of the responsibilities that we have as administrator of the program is to do community outreach. And I've been keeping up with that. Once a year, we have a mailing or sending out postcards or brochures. We did door hangers one year where we had a service physically hang a brochure on every door of every house that was eligible but not enrolled in the program.
Oh, okay.
So we try, but no, not
Well,
enough
but I
people
mean,
know about it.
that's a big deal. If
And
you-
there's,
If you did a door hanger on every
yeah,
home.
there's a lot of turnover within the realtors in the state. And so that's one of my goals moving forward over the next year or two is to develop curriculum for realtors associations so that I can go to source and educate them at their meetings and you know, they through their association, they can take classes to get credit. So if we could offer something that would give them credit, they'd be more apt to sign up for the workshop. So that it's in the works, and we definitely have more ideas, and we try and come up with ideas every year to get the word out.
When we purchased in Colorado Springs, the realtor would tell us, you know, it was an older realtor, but she would tell us when we were in that area that there was some mining issues. But I just wonder if the realtors in Colorado Springs are aware, I mean, are they really aware of this program? Seems like pretty inexpensive insurance.
Yeah, it is. And some are and some aren't. We have a good group of realtors in Colorado Springs that consistently call us every time they know that they're in the Cragmore area or the Rock Rimmon area to get information about the mines in that area so that they can pass that along to their clients, and also so that their clients know about us. So if they do decide to buy, they will contact us. So.
How many people are enrolled?
Right now, should I have those numbers? It's about 800. Sorry, I don't have the exact number, but it's about 800. The majority of them are in Colorado Springs. Boulder Weld, we don't have as much participation in that area, but we also don't have the same number of structures that are eligible in the Boulder Weld area. So.
And 800 out of how many structures would you guess are in this area?
4,000.
Yeah.
There, ooh.
Yeah, I was gonna say 4,000 or 5,000
Yeah.
homes.
Statewide.
And there are some in Boulder.
Yes, Boulder and Dacono, Firestone, Louisville, and Lafayette, Superior, Erie.
Do I have to be,
No, not Longmont, I don't think.
do I have to be
Yes.
enrolled previous to something occurring, or could I have subsistence would come and you and be like, hey, I need some help?
So as it stands now, the rule states that pre-existing damage is not covered.
Not pre-existing, but if I'm not enrolled in the program and something happens to my house, subsistence occurs.
Oh,
And
yeah,
damage
you
occurs,
can-
then that can I come and
Yeah.
say, hey, I want in on the program?
I mean, we've never denied anybody in those circumstances.
Oh, really?
No,
I mean, there's,
unless.
Well, then there's no reason for someone to get in the program until something happens.
well,
they
but
would-
that damage wouldn't be covered.
That it
So,
would
so they
still
can
be
get into the program, but whatever damage occurred before they enter the program,
Okay,
they're like,
okay.
Yeah, it wouldn't be.
so there's an advantage to getting early. There is a discussion, and we've had it internally on occasion where we recognize there is a home that if they came into the program, we would likely end up spending the fair market value to cover damage to that home, recognizing either how shallow the mine workings are associated with it, the existing damage on the home. I mean, that was one of the homes in, I think, Boulder area, wasn't it?
Yeah, it was more that they had conditions around the house that could exasperate mine subsidence, and we asked them to rectify those conditions before we would allow them to enroll. It was like standing water in their crawl space. And then they never called me back. So.
Yeah, I mean, in an interest to try and protect the trust fund, ensuring that those that are belonging to the fund are doing their due diligence to ensure that they're not increasing their own risk, that then the trust would end up having to cover the damage associated with that. So it's,
Well, if you're gonna cover a whole home, that could be, I mean, in Boulder, it could be the whole fund.
it could, and we have on 2 occasions that I'm aware of,
Yeah.
settled for the fair market value of a home, recognizing that the potential damage at some point was going to end up costing that full value of the home. So we have, in the interest of protecting the trust.
And is it just covering coal mining subsidence, or what about gas and oil like Firestone, Dacono? That's big gas and oil extraction.
It's just coal. It's, that's how the trust fund was set up, and, the trust fund from OSM was specifically for coal.
Seems like it'd be hard to separate that out in some of those areas like Firestone.
And that's certainly where having that geotechnical engineering assistance is helpful, and then understanding the kind of the layout, the other risks associated with those areas.
Was most of the mining in Colorado Springs, was that coal mining?
Yes.
Okay. I didn't know that.
Actually conducted by the city of Colorado Springs.
A lot of it.
City mine.
Number 1, number 2.
To heat
number 3.
Yep.
Yeah.
And here's just some fun pictures of subsidence.
Fun.
So,
I know you love your job.
I do love my job. But
Name that track.
that's all I have today. I just wanted to give you guys a little background so that you would know if somebody does come to the board.
So what was last time that you had to bring something to the board?
I've never have.
Not since I've been with the program.
Yeah, so, like I said, if somebody states that they want to appeal one of our, or I don't think I said this, sorry. If somebody comes back after we give them a decision and says that they don't agree with it, first we move forward and do a geotechnical investigation to verify our conclusions. And most of the time that answers the question for the homeowner and for us. So we haven't had a need at this time.
Keep up the good work. Very good. Very
Excellent, excellent.
Yeah.
Thank you for your time.
Thank you.
Appreciate it.
Who knew?
Okay. Don't believe we have any public comment. Is that correct, Tammy? And any executive session? Nope. Okay. Being said, thanks everyone for your time. This meeting is adjourned. We will see you in February, potentially for 2 days.
A day.
2 days.
Yeah. One day if we can swing it, but we'll do work.
I don't.
Hey, everybody have safe travels.
Yes, double safe. Yeah.
Travel.
We're to Denver for vacation.
Soccer games I play down here. I already live in Denver for all soccer start, and this is the basketball schedule I just wrote down. Apparently 13 games between now and.
My granddaughter is in competitive soccer and that, so they live in Temple, but